Good morning, good morning, good morning, everybody. Happy Wednesday. Welcome to Twisted Tragedies, where we follow all the twists and turns wherever they lead. I am your host, Elise, and it's a little chilly out today. I'm not going to lie. It's been nice out the last couple days. It's a little chilly out. I ordered a coffee, and of course, just as soon as I hit the button to go live with you guys, it was dropped off outside. So good job, DoorDash, for, you know, not dropping it off where you were supposed to outside my door. Oh, that is a good thing, Ashley. That is a good thing. I said, I love your stinking faces. Because I do. I love all your stinking faces. Not that you're stinky faces, but that I love all your stinking faces. Do love all your stinking faces. Sorry, I'm trying to fix the bubble. The bubble's too big, per usual. Thank you, StreamYard. Appreciate that. It's I love your stinking faces, not that you're stinky faces. Yeah, it's a little chilly. It's a little chilly. It's supposed to be in the 50s today, but the hearing doesn't start until 10 o'clock. But I thought we could try to run through. I do love my community. That is correct. Run through where Hank talks about the seatbelt. I just have to pinpoint exactly where shit kickers are not an option. Funny you say that. We got a jury. We did. We got a jury, everyone. We got a jury. So that's why there's a motions hearing today. Today is motions hearing. I am attempting right now. Okay, hold on. To get the clip here of you're welcome of Hank. I think what happened was the oh shit. The audio didn't pick up exactly what he said, so that's why it's not in the transcript, because we tried to look it up through the transcript. I had Freak look because he's my tech guy, and we couldn't look up it through the transcript, but we think we found whereabouts it would be. I'm just going back to the correct, hold on, the correct video to get it to that point. So give me 1 second while I do that before because the hearing don't start till 10. So it makes more sense to do this real quick before the hearing starts at 10. All right. So it's at 3. Three 26. We're gonna start. All right, we're gonna see if we can hear it in this. It's got to be around this area. There's a lot of motions. There's quite a bit of motions left, but I don't think you'll find her deciding all of them right now. You know what? It's not only a habit, but it also helps with my flyaways. Sometimes you just stick it up there and it pushes back all my flyaways. Although my hair is just in mom morning mode. I don't. It's in a ponytail. I don't give a shit. All right. This is what happens when you have other shit to do. So there are a bunch of motions, but I don't think that we'll find. I don't think we'll find that she'll do all of them. I think that you'll find that she'll do some of them, and some she'll wait until closer to when the trial's already beginning to answer some of them. So I think we'll find some of them today, but not all of them. So let me see. I can't remember which goddamn hearing it was in that he talked about the seatbelt. Cannot remember, but we attempted to try to figure out where it might be. I remember hearing it and thinking to myself, wow, I hope other people picked up on that, because that's big, right? That's pretty big. But it was in the last couple motions hearings, not the jury ones, but the last couple motions hearings. It's in one of those. So we're going to attempt to see if we can find it in this one. I'm not sure if we'll be able to find it in this one, but we're going to try. But it also shows, once again, just like we kind of did yesterday, going over how he cross-examines, like this is just another like way that Hank himself cross-examines and makes his arguments. Like he's not going to cross-examine in this one. In the one he did yesterday, it was his questions to Dr. Russell, but today it's going to be like the way he makes arguments in front of the judge. And you have to remember, it's going to be similar in front of the jury, except tweaked a little differently, you know? So I think it's a good point to at least hit on to see how exactly he, you know, deals with things. Like he definitely knows what he's doing. And I hope after watching yesterday, most of you understand that like he's not leaving any stone unturned. So let's see. Hold on. Right? Holds my hair back too. Yeah, I remember him saying that they know what time he took his seatbelt off. I remember him saying a time, but I just don't remember exactly what that time was. So I guess we're gonna see if we can hear it in this one. If it's not in this one, then it's got to be in the one either before or after it. But at least we narrow it down. So this is like 3 minutes around the time before he talks about the Bluetooth, but I backed it up a little just in case there's a part where we don't quite, where it's not in that part. So let's try listening to this part.
He won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview,
Hello, Amber.
Even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report,
we can't. Is that one in this one?
Witness who decided to build a potato cannon.
We can though.
For no reason.
For no reason.
No evidence that anybody threw a glass, but
none.
Apparently it was a cool idea he cited on the stand.
So cool.
That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon.
Sure didn't.
That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon. Maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me.
Trust me, Brad.
So, when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts.
You guys make me laugh.
He is a biomechanical engineer. That is a combination and study of engineering and physics and science, and it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study, and they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Lisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing.
We're back.
Except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Lisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same studies, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it did and didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30.
After 12:30.
2 minutes. We allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does.
This isn't it, because he says it. He says
the
Mr. O'Keefe takes
demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony.
That's right.
And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses.
I feel like I want to say it was close to like middle to end where he says
The
it.
defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight.
They are.
There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to
love
the
that,
court,
Jesse.
presented to the jury,
Thank you.
it shows the symmetry of the arm and the location of the arm, the height of the broken taillight.
Yeah, it is somewhere
And it
else
shows
because I remember it.
with great continuity the
Hi, Chris.
height, location of that broken taillight, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called.
Want to know
We'll
why?
have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk
we're
to Mr.
skipping.
Brennan about the reciprocal discovery.
Yes.
Okay.
May I be heard?
Sure.
Skip him.
On principle, we have no objection to.
This
an
is the
offer
end of, we're going to go to the end.
necessitated, by the court's guidance.
Yeah.
The issues do go strictly to trial strategy and attorney work product. So any
Me
such
too, TB2,
offer
me
of
too.
proof, we would ask, we make that ex parte. I can tell the court just to
Being a
kind
victim
of,
myself,
streamline
dude,
things.
it's got to
We
end.
would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers of proof at the.
Ooh, okay, we can watch
Okay.
that one.
Thank you.
All right. I'm satisfied with that.
I love
Mr.
that,
Commonwealth's
Wendy.
position. You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right. So they're both exempt from sequestration. Okay.
They're going to attempt to, Amber, but they're not going to get away with it. Hank's
So
not
the
going
other
to allow it.
motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded
Hank gets
allegations.
up.
So this is in a little
So I'm
bit
just
different
in parts
posture
where
now
Hank
than when the
talks,
Commonwealth
so I
filed
can
it
Figure out where it is.
back on March 10th, right? With Michael
is.
Proctor
Me
being
either,
fired.
Jesse.
Do you need some time to reconfigure this or you want to just be heard? And for this, I'll give you both 3 or 4 minutes.
I think it'd be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of a advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right. So you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward And then if there's anything else that
Need to
I have
forward
to
it. They
decide,
were on
how
the
long will
email.
it take you to review it and provide
Defense
defense counsel with
They have it.
everything that you believe you're required
They already
to
have it.
Well,
provide them?
They have a copy of everything that we got.
Oh, okay.
We had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh,
Yep.
okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their position is? Maybe they found him
Right.
acting unbecoming of an officer. I don't know. But those type of conclusions are what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I think till the end of next week.
Is that a same timetable you would have whoever's arguing for the defense?
Hold on, guys.
That's fine, Your Honor. I would just ask for notice about.
Pause this for a second. We need to go back to Lauren Crime for a second on something separate. All right, let's see. All right, so this is the Karen stuff, but it's on the lamp right now. So I will keep it on my screen until they actually get to. It's fully live, but it's not doing anything yet. It's not supposed to start till 10. So, all right, back to this we go.
What specifically the Commonwealth is seeking to exclude. There were some,
No, maybe.
even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but there's
So-
just inconsistencies between the title and then what's actually in the body of the motion.
All right, we're not gonna-
Discovery by Monday, the
Let's see.
24th.
Morning. This is old stuff.
All right.
We're trying to find the part where he talks about the
Motion,
seatbelt.
Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation.
Regular
I'll hear you
hearing
on
that
that, Mr.
doesn't start
Brennan. I
till
figured
10.
this is probably
I
not
have it on my
gonna be-
screen here. I'm watching it.
Sorry, Your Honor.
I figured this might be more than 2 minutes, might be lengthier than the others we've had.
This might be where he does it. I can't quite remember. I want to feel like it was at the end,
The
but I'm
defense
not
would like to call Mr. Easter to essentially testify about his personal opinions of the investigation and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a
Might
witness
be in
come
this.
in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the
Definitely,
role
Jackie.
of the defense attorney to cross-examine the witnesses, to point out the
This
inadequacies,
was
to
3 weeks
introduce any documents they have if they want to
ago.
try
a
to
month ago?
impeach the witnesses, and then the witness would have the opportunity to
Couple weeks
respond
ago.
or explain or admit any type failures. This is an attempt to bolster
Tuesday.
a potential Bowden defense and a third-party culprit defense.
Tuesday, Daniel.
It would
Tuesday.
involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be.
Yeah, no.
That would be totally improper opinion and inadmissible.
Nope.
They
He's
would
right.
want Mr. Easter to come in
Big
and
mistake.
to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state.
Nope.
If there are different rules
Yes,
and
Marathon
regulations
Monday.
that the defense will attempt to introduce, that will be a separate grounds of
That's why
whether
there's
they're
no court.
admissible and whether they can confront the witness. And a witness always has a right to explain
Never
or
know.
challenge
Jimbo, he might.
accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case
Nope.
and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to
That's
do
right.
something different.
It worked
And
since
inevitably whether
2013.
he thinks somebody is a suspect
Retired.
that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
None.
All right, who's arguing for the defendant?
Agreed.
I need you to start by telling me what you expect him to testify to.
Yeah, we're not gonna. We've already heard that,
Certainly
so we're not
tell you,
gonna.
We do not expect to seek testimony or elicit testimony from Mr. Easter as to a third.
All right, this is the
All right, can you get me that report?
so
please?
dramatic.
Do you have it extra?
I think,
All right.
I think we
He does
probably
that a
have an extra
lot.
Copy of it, yes.
You're holding your arm up with your hand, and
Mr.
this
Brennan,
is
did
just
you want to respond?
dramatic. Like really. Like, come on, man.
Mr. Easter was a
No
agent
idea.
who did
Ash.
CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about
None.
how he feels an investigation was
Zero.
done. Not a report, not an assignment, but as an expert witness in
None.
Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His
None.
experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some
50%
type of
Men, 50% women.
opinion to lean on when they're
Yeah,
arguing
more
with the jury. They should have
than last
doubt
time.
because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively
Yeah.
give their opinions.
Nope.
If there is a state police protocol that wasn't followed, then the defense can
Question
see
the
if
state
that
police.
state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why.
As of right
If this
now,
person
no.
comes in and gives opinions, there'll be a slew of opinions.
Not allowed,
That are
Jackie.
shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain
Grant knows
why
better.
they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert
Manipulation.
witness.
Karen's
I don't
best thing.
see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowdoin defense and give their subjective opinion about an investigation they weren't involved with.
Correct.
I don't know that this witness has ever been qualified as a Bowdoin-type witness in any court. He may have testified, but about what?
Yes.
And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic? That
Right?
everybody did a remarkable job under the circumstances. What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between
does.
people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony.
Nope.
This is argument by counsel.
Your Honor, very briefly.
Bingo.
I gently disagree with
Gently.
Mr. Brennan. He indicates that we want to use
Shut up.
an expert to bolster our argument.
You do.
There's another word for that, or another phrase for that. It's called presenting a defense
No.
for someone charged with murder.
No, it's
He
not.
indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers
Right, so
to
that's-
talk about
this
how
is
great
like
their
the end
investigative
of it,
techniques were?
Basically.
There's another word for that. It's called rebuttal. That's
No.
what you're supposed to do.
Yeah,
And then he
rebut.
says,
You
well,
wouldn't
hang
be
on.
objecting if they called somebody in rebuttal to
Yeah, you-
reinforce
Oh,
a great investigation?
oh, no. Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it.
Okay, good.
Do it.
We will.
I'd love that. I'd love a shot
Okay,
at that.
so I said, let's take personal.
That's
out
not
of
an
this.
invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine.
Please.
I'll put Mike Easter up against any expert they want to call.
No,
But
you
the
won't.
reality is, Your Honor, we're entitled to present a defense. And
Not
part of that defense, the
with
vote
that,
of
not with
defense
personal
is
opinions.
the
That's an
adequacy
expert.
of the investigation. And there's no question that
Let's make no mistake here. He is not entitled to bring on someone who has been retired from the FBI since 2013 to talk about how he thinks local and state PD, out of state, mind you, he's from out of state, did in an investigation. He was not there. He has no idea that the information that they knew at the time and what they did not know at the time. You do not have that right. That is not something you can bring in, and nor has it ever been brought in a vote in defense, a personal opinion of a retired FBI agent on how an investigation was done. There is case law for this, hence why there is no reason to bring one in. This argument was ridiculous, and there's a reason why the judge slapped down this argument. Like, right? Just say you're Hank. She's like, I'm Hank the Tank. Hank. Like, just kidding. Don't do it. Don't do that. Don't do that. Would be funny though. All right, so this is like the end of it. This argument's ridiculous anyway, but I remember him saying it, so I can't. Maybe it's not in this hearing. I do. Let me see. I'm trying to like scan the hearing to see if there's a spot where he might have said it ahead of time here. It could be the hearing that was before or after this one. If it's not this one, let's see. What does he say here? Where are we here? We're at an hour and something. Hold on.
It seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause,
All right, this is about the jurors. All right.
I would think, strong concern by the
No.
juror that
Pause. Hold on a second. I'm going to pull this down real quick because if it's not this one, then it's got to be the one maybe after it because he alludes to it, but doesn't say. Freak, do you know what the one is after this one? The hearings one after this one? Because that might be the one. Because he specifically says about the seatbelt that they know what time John took his seatbelt off with the new data that they have. So I want to play it for you guys because people have been hearing about it, and I remember thinking to myself when I heard it too, like, not everybody's going to catch that. You know what I mean? Like, not everybody is going to catch what I just caught when it comes to the seatbelt thing and the data. Sorry. I'm looking here just for 1 second. Give me 1 second, guys. Live streams. Let's see. These ones might only go back a certain amount of days. This one goes back 2 weeks. So we got to go to videos. Live. Do they not? I'm so confused. Why do they not go back further? Let's see. Law and crime on the case. When you go to live, though, it only shows you on Law and Crime, at least. It only goes back 2 weeks when you go and click on the things. I'm looking for a way to go back further. Hold on. Let's see. Hearing. Court hearing. Let's see. Law and Crime, you guys are really effing crap up here. Might not be on Law and Crime, though, either. Maybe it's on something else. Going to the Karen Reed playlist. I don't see that, though. See, when I'm looking at that stuff, I can't see the chat, so excuse me for 1 second. I'm looking, guys. I'm looking. Where is there a playlist for her anyway? Oh, playlists. Here we go. Um, Jesus, that's a lot of playlists, guys. That is freaking quite a bit, that's for sure. Oh, hold on, I'm getting an alert for something, and I want to make sure it's not anything super important. Nope, it is not. Also, if you guys, while you're here, I want to make sure you hit the like button and the subscribe button if you already haven't. If you'd like to donate to the channel to help us out, that's how we're able to stay, as long as we do and bring you guys all the content that we do, including the court hearings and the entire trial. You can do so at the bottom of the screen where you're watching me. There's a ticker at the bottom that scrolls by. You can do it Cash App, Venmo, or PayPal. I have never seen so many playlists in my life, dude. And there's a lot of them. I'm scanning. I can't believe she's not like right at the top. That's kind of what's getting me. Why isn't she right at the top? So it's down closer to the bottom. All right, hold on. Oh, no. We don't want to play them all. We don't want to play them all. Let's see. We want to look at them. Trial, blah, 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 blah. Why doesn't it show us in order, though? Like, that's the other thing. Why the doesn't it show us in order? This is trial. Let me try that on the bottom here. Okay, yeah, the bottom is the most recent. So jury selection, selection, hearing. Let's try this one. This is about Colin. This is the one right here. Hold on.
There were no charges. There was no evidence of third-party culprit. There were no indictments. And so,
when he's talking about
although we don't know the parameters of the federal investigation and we can only guess as to some
Brian
we know
Higgins,
from
Brian
what we
Albert.
did receive and review, it was thorough. And if there was third-party culprit evidence,
Let's see this. I remember it being either middle or end. If anybody else knows off the top of their head, that'd be great. But
yes. Your Honor, the Commonwealth filed a Rule 17 motion for records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them.
I don't think so,
extraordinarily
TV2.
relevant. Some of them from the Commonwealth's perspective.
And he was much younger.
Extraordinarily incriminating, and many of them
Right.
inconsistent with
Indictments.
statements made publicly in the past, including Dateline 2020.
Thank you, Christina.
We served the local service in Boston, a local agent.
One of the recent ones is where it is.
The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They're statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements.
Yep.
And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial.
It was quick too, the way he said it.
And they're forthcoming with a court order.
There's no one here from Unsolved Productions opposed to this.
There is not.
Does defense want to be heard at all?
Nope.
Your Honor, we're aware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first we're hearing of any communications that they've had with the production company. I think obviously
Sorry, I'm scanning to see.
in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially has been filed one way or the other. So we're not in a position to argue on their behalf, for sure.
All right. So, we have two things left to discuss. I wanted to.
Hold on, guys. Law and Crime is live outside. Hot mic moments. Hot mic moments. Damn it. They went hot mic moment on us and then cut out. That's why I have the volume on that one. Welp. This is a replay. Hold on. It says I lost the audio. This is a replay, but court starts in about 10 minutes. Just want to find the part about the seatbelt. Might be during this. I don't know. Still no audio? All right, hold on. Hold on. Might need to reshare it.
Period. And that is what is
How about now?
mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yannetti and she thought about it for 3 days. We're not looking for any information
You hear it
beyond
now?
what has been waived. We're not looking for any information on collateral issues.
I
and
have
that's
the
why
live right here.
We suggest that the court look at those records in camera, and the court makes the assessment whether or not the area in which where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are two communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, did I hit him? I hit him." And the answer by Ms. Reed was, "I said, did I hit him? Question mark. And
We're
then
looking for
when I talked to David,
where
now
handcuffs
this
with
is
the
later,
seatbelt.
David said, "Karen, if you incapacitated him in any way, there's culpability."
Yeah,
there."
me too, DJ.
And I thought, all right, maybe this is what, maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like? Similarly, in the documentary series, Ms. Reed is
You don't need a subscription to be on X, though. You
video
can
and
still be on
audio
it.
taped, and it was presented on television, that she said, "And then when I hired David Giannetti, I asked him those questions the night of January 29th, like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's
Right.
how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe and her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt.
And there
Law
can't.
enforcement officers are
Got it.
generally fair and accurate in their investigations. Who's arguing this for the defense?
I can argue it.
All right, so I don't have a problem with that, but it makes sense that we put it after 8. Those series of
These
questions.
are the questions for
No
the
objection to that.
jury
Right,
questionnaire.
Any objection to question number 13 and putting it at 9, Mr. Brennan?
I have no issue with that. It's just the way that it's phrased in the comments questionnaire.
It's confusing in my mind.
Here.
Okay, they took out your. All right, so we'll try and figure out something that way to get things moving that way. All right, the list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury and a statement of the case to the jury. Do you have that yet?
We have not combined them.
All right, so I need you to look at that,
Damn it.
and a statement of the case to read to the jurors. It's
No,
all
it's
part
not
of
on
the
this
final
one either.
conference. So I should.
I just scanned the rest of that. I guess I'll have to find it. It's somewhere. I literally, any second, I'm going to pull it up. It's got to be in one of it's in one of mine too, because I covered it. I was here for it. So maybe going through my own transcript. Somebody's going to have to teach me how to do that because that's like something I am not good at. But maybe even going through my own transcript on my own stream, I should be able to find it that way. Because I remember it clear as day. I also remember thinking to myself, like, damn, whoever caught that like I did, it's going to be a good one. Well, let's remember, as of right this very second, he is not allowed to be in there after the jury is sworn in. So as of when trial starts, he's not allowed to be there. So his stupid gremlin face will not be in the background. The hearing starts any second now, any minutes. It's supposed to be 10. I know I can't find it either, but I'll have to because I covered it. So it's definitely there. And I remember thinking to myself, like, afterwards, when I was scrolling through comments and stuff when I wasn't live anymore, I remember thinking to myself how little I saw people talking about it. So like, I was like, was I the only one that caught that? Like on how big that actually is, that he said that he has like what time that seatbelt came off? Like, you know? Yeah, I mean, I watched it, I heard it, like, and whoever was here obviously at the time must have heard it too. But I remember thinking to myself, like, not, like reading comments that like so many other people clearly didn't catch that, you know? Right? That's the thing. I didn't think to like write down the day or when it happened because I thought to myself, like, other people would know where it is. I'll have to go back and scan my own streams for it to find exactly which hearing it was in. It also might have been like NBC 10 that we watched it on and not Law and Crime. Because Law and Crime hasn't covered every single one of them. So it could have been NBC 10 or the other Court TV. So very real possibility that it wasn't one of those. Good morning, Lisa. But we will find it. We will find it. I will post it today when I find it, because I know it's there. I remember sitting here thinking to myself, like, wow, that's a pretty damn good information to have, Very good information to have. I think we can all expect too that the judge won't start right at 10 because, well, she never does. She never does. I'm 6 hours behind. Behind? So what time is it there? So it's almost 10 here, so 4-ish p.m. I do realize that being live during the day definitely helps people who are in the UK be able to sort of watch and do the live chat with us. But I am going to figure out a day I can do it at night for the people who obviously are at work right now and cannot be a part of this except for the replay crew, So I'm going to figure out at least one day a week where I can do like maybe a recap on the trial at night or something. Yeah, me too. It was one of the last motions hearings. It was a motion hearing. So they were going over motions, but I can't remember exactly which motion. Could have been ARCA. It could have been about the new data. I can't pin down in my head which motion it was. Good morning, Bella. That they were talking about it, But I know I covered it, so that means that it's got to be in one of my lives too, obviously. And they all get saved. So after I'm not live anymore, they go into my onto my YouTube and they stay there saved. So it's got to be there somewhere, Oh, see, I really need a desk. This is this table. It's like I have my chair all the way lower, like as low as it'll go. And my leg, when I cross it, bumps into the table, which rocks this whole thing. No, that's not it. It's not it, because it was specifically about the seatbelt, not the Bluetooth. It could have been that that's how they knew about the seatbelt. It was specifically about his seatbelt, though. They were specifically saying like, oh, well, we know what time Mr. O'Keefe took his seatbelt off. So that's the weird thing. That's the weird part. I have a pimple right here, y'all. Anybody got tips on how to get rid of that? Right here. It's like right here. I'm also getting one like right up here. And I haven't gotten pimples in forever, but we can all thank COVID now because I have psoriasis. And so now my face likes to break out like I'm a teenager. And I have one right yonder. And here. A Speedo. He's going to wear a Speedo just for you, Ashley says. That's the problem, though. We're trying that. You have to have like software to do it. I have like Freak, can sort of do it. But if the transcript, and the transcript doesn't always pick up everything that's said either. So if the transcript doesn't pick it up, it's hard to pinpoint it that way too. So we're working on it though. I know I do usually leave it alone, but it's like agitating me. It's like in the way. Like I can obviously feel it. I do exfoliate too because it's good for psoriasis. A sharply dressed man. Yeah, I'm losing that battle as well, Jack. I'm losing it. I'm freaking losing the battle. Although I wish I could not, because I mean, I'm gonna dye your hair every like 3 weeks, you know? Like, yeah, I don't think you're supposed to squeeze them though. I think like, you could scar your face if you do that, which I've never done. I've always just used like hot compress or like pimple patches, like stuff like that. I don't like my gray hair, I'm not gonna lie, but that's because it sticks out like a sore thumb because my hair is black. Yeah, see, every 10 days. That's about how fast my hair and nails grow, is really, really fast. Like, so like the roots, and I wish it would like fill in more because as I get older, my hair is starting to thin and it's a lot thinner than it used to be. Also, thanks to COVID. I appreciate that. I lost like half of my hair due to COVID. Morning, Kim. Yeah, I mean, I haven't broken out and I don't even know how long. And now, I'm getting one here and I'm getting one up here. Like, not a good look. I don't like it. I'm going to shut my camera off from now on. No, I'm just kidding. I'm not going to do that. Then you guys couldn't see my face. Not that you want to look at my mug, but I know. So, what do you guys think Hank's going to be wearing today? Pinstripe suit? Regular suit? I know. But I would appreciate if it wouldn't. I'm not, 65 yet. I'm in my late 30s. No man, I repeat, no man should ever wear a Speedo, DJ said. I will concur with that. I agree with you. I don't think Speedos are a good look for men, just saying. Any suit or no suit, Christina says. I just think he's brilliant. I just want to pick his brain. I just think he's brilliant. Pinstripe suit, right? I like that pinstripe one we just saw. Like, but you have to imagine the man probably has a closet full of suits. Just full of them, A blue support John O'Keefe's tie. Oh, that would be cool, but I don't think he would. I'm gonna have to use the root repair alley. Also, there's actually did you guys know this? Because I looked, because back in the winter time for my birthday, I got a year subscription to FabFitFun. And the summer box has an option to pick these tablets, vitamin tablets that turn your gray hair back to the pigmented color it's meant to be. So black, it would turn it back black. Not all of them always, but like some of them at least. And it helps with graying and stuff while also giving you vitamins and minerals. So I might pick that as one of the things for my box. I'm not going to lie. I might. I'm like one of those people that loves FabFitFun because like I like things like the cookware that you could pick for it or dishes. Love that kind of stuff. Like if I could get 3 different versions of a FabFitFun box, I would, because I freaking love them. I don't know if there's a link. I'll look. It's an option for the FabFitFun summer box. I have a friend that tried them and she's the one who told me about them, and she said it did make a difference in her hair. It might not be a ton of difference, but it did make some difference in the front of it to have it not be so gray. Not that it's going to like, cure grayness and all of your grays are going to away, but if it could help slow even a little or repigment some hairs a little, I'm willing to try it. It comes in the box, so it's not like I'm paying extra for it. I got a year subscription, annual subscription for my birthday, so I'm not paying for it. It's just an option. I think it's like option 6 or something like that. Some of them, not all of them, but some of them, yes. I did hear about a study they did on this as well, with something of repigmenting hair after it's been gray. I watched a whole thing on a study that they did on it, and I thought it was fascinating. And then my friend told me about this, and I looked, and it was one of the options in my box. And I was like, F it, I'll try it. I'm not paying any money for it. It's already been paid for a year subscription. So I'm going to get the summer box, the fall box, and then the last one I'll get will be the winter box. So I'm like, why not? Right. Well, that's the thing. I think I found my first one when I was like 23, maybe. I was early 20s when I found my first one. You guys' videos are always awesome. Yours, Sunny's videos. I watch a lot of John DePetro does some shorter ones, Matt Tympanic, and of course, Julie Grant. We watch at 8 a.m. on Court TV. She's a friend of the show. Julie is awesome and amazing, and she has no problem fighting for the victims and saying what the truth is. And probably one of the only ones on Court TV besides like Crosby and a couple of the other lawyers that go on with Vinny. Even if I was ever asked, I would probably decline Vinny's show just from watching him allow Kevin to have a quarter of the time that he gives Rocco, never mind the fact that he cuts Kevin off and shortens his answers. It just doesn't make a lot of sense to me. I don't want to. I cannot embrace it, all right? I can't. Once upon a time, nope, I can't. It's definitely not a cure, that's for sure. Definitely not a cure. Definitely not a cure. I can't embrace it. I cannot do it. Can't do it. Can't do it, guys. Listen, like, if I hit the lottery, I'm going to go get like a makeover. Not necessarily like a makeover where like, I'm just going to get like a facial to help with my psoriasis because that would be a dream. A full body wrap because I have it on my leg too. And then it's Fanny. Yeah, it's Fanny the fan. And I wish we could have patience the clock. I feel like we're going to see Fanny the entire trial at this point. And then I would get my nails done because I haven't had my nails done in forever. And then I would get my eyebrows done. And then I would get my hair done. That would be like a spa day. Like I would get a whole spa day. That's what I would do. If I hit the lottery, the first thing I would do is get a spa day. I would not. I absolutely would not. Even if I was asked, the answer would be no. I can't do it. I don't like the salt and pepper. I know you were. I know you were. The Addams Family themed. You know, when I was younger, much younger, in my early 20s, people used to say that I looked like Morticia or Nelly Furtado. It's like, oh, those are two very different people. As the fan turns. I love it. Oh my God, I love it. I'm going to have to watch it. I fell asleep very early last night. Also, I would ask very kindly of my amazing community here, if y'all could say a little prayer. My friend's son is having surgery today, and she's a very close friend. She's like family to me. And her son, he's, just turned teen. He's 13. So say a little prayer for him. He's having a surgery today, and I hope all goes well for his surgery. Because, as moms, we're sitting there waiting in recovery, like making, just constantly running through the things that could possibly go wrong, even in a very, simple surgery. Transcripts are being generated on your lives. Might be worth checking in studio. Oh, good point. Let me write that down. Or actually, you know what? Can somebody do me a favor? I mean, instead of writing it down, because then I forget to look at it, can somebody go into Discord and send me a personal message to check YouTube Studio for that, to make sure that the transcripts are being generated on my lives, because the transcripts help figure out where we can find things that we're looking for that we already have done. I have so many videos up. I don't think I could ever find it on my own without those transcripts. That's for sure. So if they're not being generated, that doesn't help. Also, there's the Discord link in case you guys don't have it. Also, I have I'll show you guys now, since we have a second before this starts. This is the pad Aviana got me for my chair. I love it. I didn't realize, though, that my butt was so large. I should have gotten the bigger size one. Or I should have picked out the bigger size one, because if it was like 4 inches bigger, it would cover like the whole chair. But because my butt is so big it don't cover the whole chair. But it is very comfortable, I'm not gonna lie. It's extremely comfortable. You're supposed to put it in a dryer to make it fluff more because it was vacuum sealed, but I don't have a dryer. I have to go to the, laundromat to do my laundry. So, but it tells you can like pull it and fluff it. So I did the best I could with that until I can put it in the dryer for 15 to 30 minutes. But it is very comfortable and it's very cute. Next time though, I picked the larger one because my butt is on like the cusp of it. And oh yeah, we got our green screen yesterday. I just didn't have time to set it up or anything, but we did get it. We did get it. What I really want is I want like a neon sign too that says the show name, or maybe even a neon sign of my name. That would be pretty cool. But I definitely want like a neon sign of my show name. That would be awesome. Like, thank you, my friends. Oh, it's 10:08. Look at that, guys. She didn't start on time. Imagine that. Imagine that she did not start on time. It's a butt pillow. Yeah, it is a butt pillow. But it helps with my pain. My hips, my butt, my legs. I have fibromyalgia and 2 kinds of arthritis, rheumatoid and psoriatic, and it is painful. And I have it everywhere. So it's not just even in my legs. It's hands, shoulder. It goes like up into my neck, down into my back. It's very uncomfortable and very painful. And there's not really anything that helps, unfortunately. I've tried so many different things. The doctor has tried so many different medications, and it just really doesn't do anything. So I kind of just suck it up best I can. Some days are better than others, though. Anybody with fibromyalgia knows how that works. It's not always fun, that's for sure. So anything that'll help ease that, pain is good for me. Especially like, yeah, it's everywhere. But the psoriatic is like spreading too. Like I have it all over. It's not fun. My daughter has psoriatic and rheumatoid in her entire body, and she's had it since she was a baby. It's part of her disease, the rare disease that she has called STAT3 gain of function. And so she's been dealing with this kind of pain since she was just a kid who couldn't talk, baby. Her doctors are amazing, though, and they started finding, what? What do you mean, Ellen? They found it when she was a few months old, the arthritis. What happened? What happened, my dear friend? Why didn't you text me? Ooh, yes, let me know. That would be awesome. That would be so awesome. Yeah, I have CPTSD myself. And kidney stone blocking. My mother used to get those all the time. Oh my god. I wish you would have texted me. You rest up. You're in the best place that you can be. That's for sure. You are in the best place. Oh, do you not have a power cord to your phone with you? He does remind me of Clark Kent. So when I do the AI, listen, if she lived in this state, I actually would, Ashley. Unfortunately, she doesn't live in this state. If she did, I would. She'd be my co-host off camera for the day. Yeah, they are not comfortable. Kidney stones are awful. I've had them a few times. Not in a really long time, but I remember the last time drinking the cranberry juice and it, helping a little, but being like, I hate cranberry juice. Okay, perfect. No worries. You rest up. You rest up. Sometimes there's a nice nurse that can give it to you if she has a phone, But it depends on the hospital, It depends on the hospital. Come on, Kanoni. Love you. Love you. Yeah, that MS will do that to you too. They tested me for MS when, it was fibro and everything, tested me for Lyme, MS, all these different crazy things. And I had no health problems pre-COVID, except for my liver, which I was born with liver issues. So I have some liver issues that I was born with it, been dealing with my whole life. But other than that, it's pretty healthy before I got COVID in 2020. And after that, I have now had a million issues, a lot of inflammation. I have myocarditis now, which I did not have before. And obviously, arthritis, fibromyalgia, all these psoriasis, all those things I did not have pre-COVID until after I had COVID. And it caused all this inflammation in my body, which they cannot tell me why or how. Were you, Parson? No freaking way. No, I was born with a liver problem. They had me in an incubator for months because I was had a liver issue and it was jaundice. So I was born with that liver problem, unfortunately. I know. I just have a habit of saying things like this. I set myself up for it. I totally do. To be fair, it's still funny. Like, to be fair, I don't know, but the judge has taken her sweet ass time per usual. Come on, Canoni, aka FKR calls her Canoe. You know, Canoe. I do think sometimes she's a douche canoe. If does that count? Like, I did not. This was pre-vaccine ever existing. Actually, I got the first strain of COVID that hit the United States. I was so fortunate to get that very first strain. My husband got it 2 or 3 times, and as he got the different strains, it got less and less, like, it did less and less to you. Like, it was like a cold at the end. And second time he got it was sort of like the flu, but not as bad. But the first time, the one that I got it, I went to the hospital because I couldn't breathe, thought I was gonna die. And at that point, they didn't put anybody on ventilators yet. Thank God, because I probably wouldn't be here with you today. So they gave me a bunch of breathing treatments and a bunch of medication, just like flu meds, basically, and a couple of breathing treatments, and sent me home. And for the next 3 weeks, it took weeks to get better. It was awful. I had to sleep with 7 pillows under my head and sleep half sitting up because I couldn't lay down to sleep. It was awful. And I already have sports induced asthma. So it's basically asthma when you're exerting yourself, running or anything like that. I've had it since I was a kid. So yeah, it was super fun. They do not get it, Agent 99. People who don't have it don't understand. They also assume that we should just be crying all the time if we're in that kind of pain, that if we don't complain, that we must not be in that kind of pain. I've learned to just kind of suck it up. And so just because I don't complain doesn't mean I am not in serious pain, That's kind of how it works. But my wish list, I haven't really put anything on there for comfort for myself. Honestly, it's mostly stuff I need for the show, maybe some things for my little for Easter, which is I am dreading the thought of having to do any Easter shopping today because I'm going to have to. And I'm on a limited budget. So, but I mean, you can, with the wish list, you can actually buy things that are not on it. So if you find something that helps you that will work for me and you think will help, you can put something in the cart that's not on the list and still send it. I set it up that way. I'm not sure though if you have to buy something that's on the list and then send it with that, or if you can just buy something else that's not on it. But I did set it up. It does say people can buy things that are not on the list and send it as a surprise. So not really sure how that works if you have to buy something on the list to do so, but there are some little cheap things on the list too. Most of it is stuff that I use on a daily basis, toilet paper, paper towels, juice boxes for my kid for school, the water that we drink, things like that. Everyday things that cost money that we all need. Needs, and I think I put 2 things on there actually for myself other than this pillow on my butt, which was a jumpsuit to wear for Easter, which I didn't get, and then I think a shirt and a pair of pants, something like that. She might be. You never know. Maybe she went to get pickle chips. Karen went to get pickle chips. I mean, it's 10:15. Y'all set it for 10 o'clock instead of 9 o'clock, and then you're late. Come on, man. This is a little redonkulous. All right? Redonkulous. Let's get the show on the road, Canoni. Let's do this. I don't get it. They're going to have to start trial on time because you have jurors there. You know what I mean? I think without the jurors, they kind of take advantage. Even with the jurors, they kind of do what they want. But it's come on, man. Like, come on. Like, let's get this show on the road. It's 10:15, 10:16, and we haven't even started yet. Like, Fanny's up there spinning her wheels over there. Like, huh, that would be amazing if she just took a plea. I do not think that will ever happen. I think when she's found guilty, and I say when because I'm manifesting that's what's going to happen, she'll just appeal, of course, until the cows come home. Probably 20 years it'll take to keep doing all the appeals. But she's going to appeal, of course. Appeal. That's what people do who don't want to be sitting in jail for something that they have convinced other people they didn't do. But you know what? If she stopped for donuts, then Canoni better drop me off some donuts. She can just like throw it from Dedham. I'll catch it. Like, I like donuts. Like, right? She'd be in the bathroom mirror just admiring herself. Like, oh my God, you have no idea. They would lose their ever loving minds, is for sure, Parson. That is for sure. Like, that would be amazing though, Jack, if she just took that plea. Like, take it. Please, for the love of God, take the plea. Like, we can all have this over and done with. Or it would be great if the sewer turtle would just flip, but he knows that his life's already over after this, so he's got to continue to grift for as long as humanly possible. So he can't do that. He's got to just keep acting like he's fighting for Karen and keep doing what he's doing because he's got limited time to keep bringing in funds until his own trial, when people realize with the evidence that he has not only been lying to them, but that he despises his entire audience and thinks they're all idiots. So I can't wait for that to happen, because it's not so much that I want to like stick my finger out and say, I told you so. It's more that I feel bad for some of the people who have been duped, but for the really vile ones, the real disgusting ones that think that it's okay to like harass and cyberstalk people that never respond to them and don't even think about them unless they're like attacking them, then I feel like it's a little redonkulous to actually believe that like this, like these people don't already know she's guilty. Like, come on now. One second, guys. I gotta help my hubby with something real quick for 2 seconds. A show of cyber hands. How many of you guys would be really pissed off if you paid extra money for 2-day shipping and then
Look
it
at the way they
didn't come?
explain the 2-day shipping.
It says 2-day shipping doesn't mean you will receive the package within 48 hours
How
of
the fuck
placing
does
the
that not
order.
mean?
You guys, it says instead, it means you will receive it within 2 business days.
And
Once
Saturday and Sunday don't
don't count, yeah.
That's
Once the
unbelievable.
item is shipped to you Monday through Friday. So if you order it on a Saturday,
Until Monday, it should be here today.
yep. That's bullshit, guys. You guys can't tell me that you don't think that's crazy. It literally says on here that the 2-day shipping doesn't mean you'll receive the package within 48 hours. Okay, well then why have an option to pay for, I get it. I get business days. Like everybody knows Sunday's not going to be a day your shit's going to ship. That's like well known. But don't have an option for 2 days. Like they could be sued for this. Like even though they specify it on there, like when you're checking out, it doesn't say like it will not be, or given to you in 48 hours. Like you're paying extra for that 2-day shipping. You know what I mean? If you need something. Outraged for my husband, you guys. We're outraged. Tell him we're fucking outraged. How dare they? Like, no quickies while I'm not allowed to do that? Well, thanks for telling me.
You guys are too late.
It's your cousin from Boston. My cousin from Boston. That's hilarious. Christina Rex said start time's 10:30 now. Well, that's nice. I love that they just decided, halfway through that now it'll be 10:30. Like jerks. Like she can take a plea all the way until the jury deliberates. She absolutely can. In Massachusetts, she can continue. She can take a plea if she thinks that the case is starting to go south for her. She absolutely can. He needed smoochies. Is that being run by Jackson? Right? That goddamn scam. Yeah, or when they get fly. It's a glove. It's his glove that he needs for softball, for tournament. His glove is like 25 years old. It's an old ass glove. So he definitely needed a new glove. Like his glove was extremely old and yeah, broken, but like he still played with it for I don't even know how long. And since he's such a good player, like he made it work. So, but he got himself a cheap glove that wasn't going to fall apart quickly. And yeah, the glove's pretty bad. The old one's pretty bad. So he definitely needed a new one, but he found one for a really good deal because they're usually like $4, $5, $3, $200. He found it for a way better deal and paid for the 2-day shipping because he's got a tournament on Saturday and it wouldn't have come in time and it should be here or should have been here yesterday. And, it's not. Also, I'm waiting on my Justice for John sweatshirt. It's a champion one like this one. And it's blue. You could pick from black or blue. I picked blue. It was pricey, I'm not going to lie. But now I need a t-shirt because it's coming to t-shirt weather. And now I only am going to have a hoodie. But I thought the hoodie would be appropriate because I'm from Boston. And that's what we do here is wear hoodies. Like, hello. That's what they should do. They should make it much clearer. Instead of saying 2-day shipping, it should, you know what I mean? Like it should be clear. That's how they can get sued. Oh, they have that? See, I don't order really from anywhere much because, well, I'm a broke bitch. So I don't usually really order. And the problem with that is that I don't have a car. So it's really hard to like, I can't pay the extra money to have it like delivered or shipped, which way I would love to do, especially for Walmart, because Walmart, there's 2 Walmarts within like 3 miles of me. And it would be great if I could get the stuff delivered to me that I need, like socks and underwear for my little. She needs pants desperately. She needs shorts for summer. And I put some of those things on my wish list because I'm always, you know, of course, my kids come first. Everybody comes first. So I really didn't put anything much for myself. But everybody knows the stuff I like. Anything that's pink, glittery, or has skulls, I love it. Or anything for comfort. Anything for comfort, I'm in on. Sorry, guys, they did not put sugar like in my coffee. They literally put 1 sugar because DoorDash is so wonderful that the option that they had is just cream and sugar. They don't have an option for how many for some reason. Like most other places have the options for how many, but for Mary Lou's, they decided that it would not be smart apparently to put how many sugars and how many. So I had to sort of add my own sugar to this because it was not tasting good. I have Prime. It actually comes with my phone bill. Otherwise, I wouldn't be able to afford the extra money for it, but it comes with my phone bill. So I do have Prime. Thank you, phone bill. It's like an old plan, like so old. Metro PCS had the plan, like, I don't know, I've had it for years, but it was part of my plan forever ago. I don't even think they offer it anymore, but because I'm grandfathered in, I still get it under my phone bill. That would be nice, right? Pizza. We all talk about pizza so much. I've had a lot of pizza lately. It's so good. I still have to figure out what the hell I'm doing for lunch this entire trial. Like I need to prep something, whether it's sandwiches or salads or I don't know, something. I have to prep something. Oh, I have seen that you can get like a credit if you like say that it can be like a day later and it can all come in one box and they'll give you like $1 credit or whatever, depending on what it is. It's a possibility. You have that plan too? Yeah, see, that's the one that I have. Oh my God. I heard about this morning. I was like, they what? They went to outer space for 11 minutes. The whole thing was like 11 minutes, I guess. Interesting. Interesting. Well, apparently it's supposed to start at 10:30. We're 4 minutes off from that. Let's see if they do. Like, I love that they just decided this morning that it'll be a half hour later. I wonder which attorney was going to be late that they decided that. because that's what I'm guessing. Someone was going to be late. Otherwise, why push it back a half an hour? We have no idea what motion she's going to decide on at all. Like, she wanted to be a firework. I freaking love you guys. I'm not going to lie. You guys had me rolling yesterday. That chat was off the hook. So if any of you guys weren't here yesterday, the live chat should be loaded now from yesterday. You need to go back. If you didn't watch the live chat as you were watching me yesterday, you need to go back to that video from yesterday and open the live chat and read it as you're rewatching yesterday's live stream, because if you don't pee yourself, then I don't know. Like, it was pretty funny. I'm not gonna lie. There were a lot of ones I went to burst out laughing and I had to hold it in because it was so funny. But that was that live chat yesterday was wild and hilarious, and I couldn't love you guys more. Literally, like, could not love you guys any more than I did yesterday. She went to outer space with blue sky. And a couple other rich people went too. So there was like 5 or 6 women that went. Right? Red carpet treatment. That's the only Katy Perry song. So I can't do any more puns. Well, she did go with girls, so she might have kissed a girl and liked it. I'm not sure. Yes, you can read the live chat in replay. So when you go to the video, right, from the day that you're going to go watch, it takes like 2 or 3 hours or something like that to load after. So like right after I'm live, you won't be able to see it. But if you wait like a couple hours, it will load. And so when you go to the video, it'll say comments. And if you scroll over, it'll say live chat replay. So right where the comments are, it should be like 2 circles. And you scroll over if you're doing it on your phone, and it'll say live chat replay. And you click on that and the live chat will pop up. And you can see the live chat as it was happening when I was live. It's hilarious. If you like, Jack, I'm telling you, if you don't go back and watch the live chat and read those and pee yourself, then then I don't know, because it was freaking hilarious. I'm out. It was one of her songs. It was a literal comedy show. Like, I kid you not. It was a comedy show over here. Like, yeah, we do that while the world is starving. Isn't it amazing? Like, listen, I'm going to tell you right now, if it were up to me and it was like, hey, Elise, you could pay $4 million to go to space for 11 minutes, or you could write checks, knock on people's doors that live in apartments, and write checks for $10,000 and give them each a working brand new vehicle and a home, whether it's a condo or a house that you could use all that money for. That is what I would do. I've literally have these plans in my brain for if I ever hit the lottery. Like, I am going to buy all the empty schoolhouses that are all over the country, and I'm going to turn those into apartments, and I'm going to buy them outright. If I was this rich, just buy them outright. This is what I would do if I was Jeff Bezos. I'm going to buy them outright. And the families that are going to live in those apartments are going to be able to just pay their own electric and gas, because I'll own it. I will own it. So they could pay their own electric and own gas and like $100 in rent and save their money so that they could buy their own home. That would be the stipulation. You pay $100 in rent, you pay your utilities, and that's it. You pay your utilities, your gas, electric, cable, whatever. And then you can save the rest of your money to move out and buy your own home. Here's $10,000 to start. Here's a brand new car to get around. Like, that kind of leg up could save people from poverty and being stuck in this whole, living paycheck to paycheck and only making enough to pay the bills. If they had that sort of boost, that sort of start, 10,000, a brand new car without any issues, and a place to live that didn't cost as much as they make. Like, I've literally have been planning this for a long time. Me and my husband have thought about this so many times on what we like, the things that we could do. I'd be like Oprah, except my own kind of Oprah. I absolutely loved the comedy show. Keep it coming. Keep it coming. That has always been my plan. If I hit the lottery one day, Like, that's the plan. And if I can't do all that, and it's not that much, I would still like to at least knock on some doors and write some personal checks. Most places do it because it's like a tax write-off to their nonprofit. Screw a nonprofit, because the problem with nonprofits is you have to fit a small subset of criteria to even apply or be considered. I don't want that. I literally don't want that. What I want is for people who need help, and some people are just too proud to even say like they need help. Okay, for those people who are living paycheck to paycheck, and who, first of all, I will tell you, from someone who doesn't have a car now and haven't had a car in well over a year, probably close to 2, it is hard. And I've never not had a car this long, but I cannot afford thousands of dollars for a vehicle. I just can't. I just cannot. I am barely scraping by as it is. Groceries are a problem. Never mind thousands of dollars for a car. You know what I mean? Most people can't do that. Like, it's just not an option. So a brand new car to people who need a way to get around, there are jobs that people could take that are half hour away or so that would make them twice as much as what they're making right now, but they can't get there. And Ubers would cost too much of their paycheck. A car is everything to some people, especially in areas where I live, where there might be like, we just got like a purple line that's coming and going from Boston. But again, that runs every couple hours. We don't have like regular public transport where I live. There is none of that. We're not Boston. This isn't Boston. So there's no buses that are running all around. We have buses, but they're on one side of town only. So if you're on the other side, and they only go to certain places. So, like, there are reasons people need vehicles. Like, I have all these beautiful ideas in my head. So if I ever hit the lottery, I guess you have to kind of play the lottery as well, right? To win, because I don't usually play. Once in a great blue moon, I'll buy a scratch ticket and be like, hey, I'm feeling kind of froggy. Most I've ever won on a scratch ticket was $1,000 on a $10 scratch ticket one time. Before that, the most I won was like $100 on a $1 scratch ticket on the day that I turned 18. It was my birthday. And I bought like 10 $1 scratch tickets, and I hit for like $100 on like the second one. But that's pretty much it. Like, I don't usually play the lottery unless it's like a big number for like Powerball or something, and then I'll play a couple of tickets. But other than that, I don't really play it. But I'm like, I have this dream that I win the lottery and I'm able to help all these people and my own family and the people that I care about. And I buy this huge plot of land, and I make a street, and I make it a compound of just houses. And not just for family, but for people that I know that have become family to me, really, really close friends that have just been by my side for as long as I can remember. And those people deserve a home right there on the street that I build to help them out. Follow gas tank. Do you have a Santa Maria to go with it? If I could get something and like pay somebody in payments or like something like that, then I might be able to afford it. But I cannot afford one whack of a couple thousand or even 1,000 at this point. Like, that's the problem, right? I used to be fine until I thought it was a teapot. I mean, are you a teapot? Are you short and stout? Do you have a handle and a spout? Judge is still late, guys. 10:35. Where is she? I need help with the psychiatrist. Keep jumping out the window. Right. I think we all have dreams about what we would do with a ton of money. I don't need 7 houses in 7 countries if I had that kind of money. I don't need 17 cars. I need a modest home, 2 working vehicles, one for me and one for my husband, right? And a bank account to not have to worry about being completely broke. Like, that's, I think, what everybody needs. Everyone needs just those basics, Like, yeah, that's the other thing. Down payment until you can't afford the payment anymore, and they come and repo it, and you just flushed all that money down the drain. I wish. Could even. There's a rude version of that. I bet there is. I bet there is. But for now, all you guys get. I mean, I'm not a millionaire or a billionaire. I wish I was a Jeff Bezos or a Musk, but they don't really spend their money on things like that sort of matter. They spend their money on ridiculous things. Like, I'm not saying that if I was rich, I wouldn't buy something ridiculous. I'd probably buy something ridiculous. But I wouldn't just keep buying ridiculous things. It's kind of stupid. I'm on making memories. Memories are what I like. Trips for my children, memories like that. Like, I'd rather go on a trip with them for a memory than buy them a bunch of random shit. Like, Central air conditioning. Rust, I love you. Ah. Like, seriously, though, it's 10:36. Like, hello, paging Judge Canoni. You changed the time to 10:30, and we are waiting. Paging Judge Canoni. Could we get on with the fucking show? I don't know what motions she's going to be covering. Nobody will know until she actually starts covering them, because there's going to be some of them that she's not going to do today, guys. There just is. There's going to be something she's not going to do today and that we won't see until like trials actually starting, unfortunately. I guess this is a good time to say, like, we've been here for an hour and 37 minutes. If you haven't already, all 193 of you, which is actually short for today. I'm surprised. But I know Kevin's live right now too, or at least he was supposed to be. I'm not sure if he went or not. It didn't give me the notification, but now be a chance to hit the like button and the subscribe button. And if you can, donate to the channel. If you can't, the subscribe button and like button are just good enough. And these are the 3 ways on the screen that you can do so. Cash App, PayPal, or Venmo. I do read them. I don't read the government names. I only read screen names or first names. If you want to remain completely anonymous, you just write ANON, or fully write just anonymous, and I will not read it. I won't read your name because, we don't need people being harassed. And that's what happens with the mob. So, but there's a ticker at the bottom of the screen. See right under that thing that says Karen Weed murder trial? They have a ticker. Law and Crime has a ticker. Mine is directly underneath that on that same screen. Some people miss it. Mark pointed out to me the other day that he was looking at the bottom of YouTube. So I should be more specific. Get some more specific now. It is on the same screen that I'm on, just down here. Not on the bottom of YouTube, but on the bottom of the screen that you're watching me on. And all the information is there too. And Ashley can pop it in there in case anybody needs it. Ticker inception. Yeah. So many people all the time ask me, can I make the ticker bigger? I can't make that's it. That's the size that they give you. It's kind of annoying. Like, cannot make the ticker bigger. The only other way I can make it bigger is to pop up the bigger one. And again, I can't make that smaller. So it's like, there's no freaking happy middle ground on these. like, none at all. It's obnoxious, kind of. I'm not going to lie. It is obnoxious. Benadryl has a recall, y'all. Just saying. Product recall, car seats, baby food, and a recall for more escapes, 33,000 escapes. Mine was before it caught fire, recalled, and that was fixed, and then the car still caught fire. So isn't that amazing? That was a couple of years ago. We had only owned it for a few months, and they had a problem, the Ford EcoBoosts, with engine coolant pooling and starting a fire, and it literally burned my car down. Caught fire while driving. And the entire thing was a loss. Thank God at that time for gap insurance. We had gap insurance, but we were also then left with no money to get a new car and no car. So thanks, Ford. Appreciate it. I'm part of a class action suit against Ford, but it's been years and still no resolution. So Benadryl recalls 2,000 bottles due to a lack of child-resistant packaging. Well, rear view camera issues on Ford malfunctions. And then another second recall for Escape, Broncos, SUVs due to fuel leak. Shocker. That's amazing. You couldn't get it to work? It should pop up as Wicked Pearls and personalization. It should work. Let me know if you're still having issues. It should work. Is anybody having issues with PayPal? Do I need to go check on it and make sure? That's the thing. I don't really have a way to like making sure that it is. I know that it was working yesterday because we got one. We got 2 yesterday on there. One from Eva. So it should work, but when you go to it, it should say Wicked Pearls and personalization. It's my business account for pearl jewelry that I make. I haven't made some in forever at this point. Just don't have the time anymore, honestly, and I need more certain things to make it. Oh my God, that's hilarious. I mean, he did pee himself. He said so. He did say so. Let me know if you're still having a problem, Jen, or if anybody else is having an issue. Is anybody else having an issue? It was already supposed to start, Anna. Like, what are they doing? It's 10:42. Y'all said 10. Now it was 10:30. Like, what the hell? Let's see. I mean, Cash App and PayPal is always better anyway because it doesn't take fees, and PayPal does. But some of you only have the option of PayPal because you don't not in this country, or you don't have Cash App or Venmo. I mean, Cash App or PayPal, Venmo, yeah, Venmo. Oh man. Interesting, though. That'd be interesting to watch, don't you think, Kim? If he's called in and they do a voir dire of him pleading the fifth to everything, like, let's fucking do it. Let's go, dude. Let's go. I have not, and I don't intend to. Interesting. So, for all you listening and can't are not reading, Kim said that the sewer turtle tweeted that he was called into court this morning. Although I take everything he says with a grain of salt because he's a freaking liar. Said that must be the delay. He said he'll be there at 11:15, maybe for Lumen Martin hearing. Interesting. It'll be a closed hearing. Why though? Why would it be closed? Usually all the hearings are. Yeah, I get, but that would, if that's the case, then why are we still waiting now? Why wouldn't they go forward with the rest of the motions right now until he got there at 11:15? Because if that's the case and they intend on doing that at 11:15, then we won't see anything until after that. Doesn't really make a lot of sense to me. I don't know. Parson says, breadstick money, and sends $5 on PayPal. So it looks like PayPal's working. Thank God. Thank goodness. Yeah, thank you, Parson. That's the thing. If they close it, like, why wouldn't they have called him before now? And why not do the rest of the motions that you have until then? You know what I mean? Like, exactly. They should be doing other motions while they wait. Like, so what in the actual hell, like, is going on? They want to start this trial Tuesday. You can't start the trial Tuesday if you can't even get your shit together. Like, come on now. They said 10, then they said 10:30. Now we're talking 10:45. Like, hold on. Let me check real quick with someone. Victoria George has requested it should be the attorney of license that all of the other attorneys are under. Something's weird. Yeah, that's not normal. Why is Yannetti backing out? Because they wouldn't need to be licensed under anyone else but Yannetti unless he's backing out. That's interesting, Aaron. Aaron said that, yeah, Victoria George is requested to be the attorney of license that all the other attorneys are under. But she's not even a criminal attorney, so I don't. What the hell? Something's up, guys. Something's definitely up. Yeah, he could be having to be a witness, like I told you guys before. So if they didn't stipulate to certain things, he might have to be a witness, and then he would not be able to be Karen's attorney. Same thing with Jackson. So I don't know. Something's up, that's for sure. If he's going to be a witness and he's not stipulating, this is kind of why Hank sort of cornered them into either being like, okay, you can stipulate to these things, or we can get you on the stand and you can be a witness and you can testify. The problem with being a witness is then you can't be Karen's attorney. So if that's the case and he's going to have to be a witness, then he can't be Karen's attorney anymore. So they want Victoria to use her license to license the other attorneys. Why not just stipulate? Yeah, I did hear that. We just talked about it. Even if he had to miss a day, though, I don't necessarily think that she would need to cover their licenses, except for they're still practicing under his. The only reason that they would need to switch that under hers is if he is not going to be an attorney anymore for her. So something's up. Let me check something real quick. Let me just check with someone specific real quick. Elise got sources and I need to check with them. Hold on. Let me ask two of my very something's up, that's for sure, guys. Something weird is going on. Yes, Amazon gift cards are always useful. Amazon, Walmart. Is PayPal not working still? Is that like the problem? They do suck though, I'm not gonna lie. But yes, of course, Amazon is always helpful. Walmart. Mary Lou's news. My coffee place. The motion's on X. All right, let's pick that up. Hold on. Let's grab the motion and see what it says, and I can read it. If I can read it, hold on. I just like totally got my little mouse pad here thing a little bit wet with my coffee. Let's see. Oh, come on. Now that I got it wet with the little bit of water from the coffee thing, now it's like messing around. Doesn't want to go where I want it to go. This is why I prefer a regular mouse, but I don't have one. Well, I have one, but I lost the little thing that goes into my computer. I have a pink one, but I can't find the little piece that goes into your computer to use it, unfortunately. No, it definitely isn't. I wish it was that, but I definitely feel like something's fishy. Something's going on. Let me see. Mary Palmer, you dumbass. Yeah, you could send it to the Gmail in the ticker, yeah. That one or twistedtragedies3@gmail. Let's see. I checked with my sources. I have to wait for them to respond, but let me just check one other place real quick and see. Interesting. Something's definitely up. That's for sure. Let's see. Hearing starting right now, 10:49 a.m. You can stream on WBZ.com. Wait. Whoa, here we go. Here we go. Make sure it's unmuted. Yep. Okay. Can we get audio here? Hello? The basketball hoop. We don't have audio. There's no audio yet. They haven't turned their audio on yet. Good thing I just checked. She literally said starting right now, and it was seconds after she had written it. I can't, there's no audio. Hold on, I'm going to find WCVB and switch to that one. Because we have no audio right now unless it magically comes on. Nope. No audio there either. What the hell? There's no friggin' audio. Hold on. Let me tell one of the So Christina Rex has no audio. Court TV has audio. Maybe that's the problem. Hold on. Hold on. Gonna make it bigger. Hold on. We'll go back after. Damn it. Hold on. I have to redo it. The audio.
You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because
Sorry, I shared the wrong one. Oh, fuck. Damn it.
a USB drive, then all of the associated metadata would either be destroyed or otherwise
Thank you, Erin.
unverifiable. And of course, right
Can you
after
guys hear
we
this?
filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer
Good, thank you.
that our expert can glean if that data is properly imaged.
You don't need
The
metadata.
import of this video surveillance cannot be overstated. This is a seminal issue at
Okay.
trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this.
No.
I would
not gonna
also
give you
note
metadata.
that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and
You
we're
do.
asking the court to order
You don't need the
that be
metadata.
properly imaged for our review.
They gave it to you
Okay.
already.
Thank you. Mr.
Everything but
Brennan.
the metadata. The court already said no to this. You don't need metadata. You're not entitled to metadata.
It seems the defense characterization as forensically sound is fluid.
Yep.
It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me.
Mhm.
Right, so you asked the
Yeah.
question to me.
Little.
Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case.
I got it,
And it
Anna.
would,
Thank you.
Then intrude upon private information and other investigations. They can go
You.
to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
That's right.
Okay, thank you. All right, so the next motion.
Nor are they
we're
entitled.
going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do it?
No, right?
Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I would think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to.
And you
figure
didn't.
out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were we were not on the same bus as the jurors.
No.
Yes,
and
we
won't be.
were.
We're just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the
Nope.
better practice would probably be for the defense team
Going to the Fairview
arrive
to
and
walk
at the same
the car-
time follow the bus in a separate
to
ticket,
see the
which
house.
we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors.
No.
But just be there,
Absolutely not.
able to observe the same circumstance that we observed last time.
Absolutely not.
So I'm not going to allow
Nope.
all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and
fine.
the rest will be on the bus.
That's fine.
There you go.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I
Yep,
thought it was
no.
unfairly prejudicial to the defense.
It is.
They decide,
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at Sidebar about this anyway?
Sidebar. She said sidebar. I guess we'll start with the fact that she said sidebar and play the sidebar thing that we used to play. We have to get new clips. I have to get somebody to make me new clips for this trial.
I think we got a super chat. I think we got a super chat.
Salad bar, sidebar, all sorts of bars they got going on. And the only one that Karen likes to hang out at is the real bar. Oh, look at these cartoonish critters over here. There's Mr. Burns. Smithers is on the other end of that shit show. Yeah, it's going to be a bumpy ride for y'all. A bumpy ride. Still not sure why Esty is sitting with the Reed family other than she gives lots of money. Right? You mean the hellhounds to bring them back where they belong to hell? Yeah, it's not the finest of mass. Yeah, I don't think there's a reason for her to even have to go to the scene, to be honest. But whatever, dude. You want to go to the scene where you committed the crime, go for it. Like, I do think it's really unfair to the jury, though. It's not nighttime. It's not snowing. Like, you put a car there. Like, okay, cool. You put a car there. Like, I mean, it's going to be hammered into their brains what it looked like anyway. Reasons not to get plastic surgery. Right. She didn't need to go the first time. Why does she need to go this time? You know what I mean? Doesn't really make lots of sense to me, but whatever. Whatever. Thank you to Anna from the House of Biba for the $25 Amazon gift card. I appreciate you, my friend. It will go to good use, probably for household items like toilet paper and water. So the motion I'm looking at, it doesn't really tell us much other than Victoria George is trying to be the counsel for the other attorneys. But it points out that she works for Unetti's firm, so why would it need to be changed to her? It's already on Unetti. You know what I'm saying? I will act as co-counsel, is what she's saying. Co-counsel. good cause exists to grant this motion because Attorney Jackson, Attorney Little, and Attorney Lessie have specialized skill and knowledge in representing defendants in matters of this nature. Yeah, but why do you to serve as additional local counsel? There's no reason for it. Will remain primary. David Yannetti will remain primary local counsel for Jackson, Little, and Alessi. Then why do you need to even be on it at all? This just like something's up. Something weird. They're trying something weird. I got to figure out what it is, but there's no reason to add an attorney like that at all. So I'm not really understanding. Yeah, probably not, Erin. I'm guessing probably not. I don't know. Maybe Kelly Reed. Thank you, Anna. I mean, it's only a couple of cents. Usually it's like $1 for $20. It's like some cents for anything under 10 or something like that. It's not a ton, but again, they hit me with another like 3% fee when I put it into my bank account, but cash is always useful. You know what I mean? Especially since I don't drive. I always have to, pay for somebody to bring me somewhere, gas or otherwise, or Uber, Lyft, Yeah, I know her husband is like a surgeon though, so that makes sense. If her husband's a surgeon. The worst parents ever. I can. Yes, I can. Definitely can. Thank you, Anna. I appreciate you, my friend. The worst parents ever. You guys kill me every time. Show Smithers. Show Smithers. Show Smithers. Yes, my sidebar can be found on Discord. My wish list is on Discord. Okay, here we go.
All right, so on the defendant's list, I don't understand the motion regarding
Miss George.
Dr. Welcher,
Oh,
because that's been decided. So why is that appear on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
what agreement?
Okay, what's the agreement?
Right.
What's the
Idiot.
agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
Right.
All right. Thank
Thank you,
you.
Your Honor.
Okay.
Well, that's fair.
So Lieutenant Wing,
Good idea.
docket
Good idea.
607 and 658. So
Ooh,
what I want to know
Parrot Wing.
about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes.
I
Mr.
would
Wing as
never
a
potluck.
dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing.
Yep.
He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only
She said that.
qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a
What the
dog bite.
hell? Yeah. No.
It doesn't appear that Mr. Wing is a certified, it doesn't appear that Mr. Wing has
What the
ever
hell?
testified in court before.
Nope.
So to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness. in this case.
Hey, Arlene. Hey. Yeah, that's it. Back row is literally there to make money. That's like Karen's job is all the back row is like her, people who donate the most.
Thank
to
you, Your
make her more
Honor.
money.
With regard to the report, I just want to underscore that there are changes.
Yep, DJ.
And I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide
Great.
the court
Set up.
with that forthwith. The second is on the substance.
Come on, bro.
Lieutenant Wing is extraordinarily
That's my
experienced.
ass.
You will see that in his report. The summary of his experience, because it would take a lot of time to go through it.
Oh, shut
For
up.
several years, he's been one of, if not the country's leading experts
With no
on
certification.
training law enforcement
No
with
certification.
regard to the use of canines, not only with bite and hold techniques,
The feds are coming.
but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs.
No, washouts
He has
are service animals.
extraordinary
It used to be,
experience
or canines used to
with
be, and they walk.
wound recognition.
It's not the same thing.
Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition.
This represents what a wash is.
His methodology, unlike that of Dr. Crosby, is stated in his report. And in addition, he cites two specific studies for his report,
do those
including
studies?
pattern recognition.
No.
And the whole topic of pattern recognition was well established through Dr. Russell.
So he's Dr. Russell.
So Your Honor will
So you don't need
see
him.
that as well.
So you don't need him then?
My last category of points to make, Your Honor,
You have Dr.
is
Russell?
this.
It's the same thing, right? You don't need him?
The timing of this
you just
report
argued.
came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And
Yeah.
we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And
Bullshit.
it is part of that in
Why?
light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior
Bingo, Jack.
in combination with the wound recognition is different from Dr. Russell. There is overlap,
You
but
said it was
it's
the same.
different. And the bottom line here
Said it was the same.
is that the approach of Lieutenant Wing and his qualification
So two of your experts are saying something different?
exceed that
Come on with
of
the
Dr.
buffering.
Crosby.
What is happening?
And my request, Your
It's not
Honor,
my internet.
is I do not believe there is at
Come
all
on.
a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby.
No,
We have
not
made
having
that
that.
request
not happening.
of
Come on,
Dr. Crosby.
buffering court
That's
TV.
another motion. That's what we're going to hear now.
Understood. And I was just going
Oh
to
my
say, I
God.
am not going to get into the
This is
basis for
noxious.
that. I just wanted to, because,
Just go ahead. Just move on.
yeah, so my request would
What is happening?
be that a determination on
Why am I hearing two?
whether or not there's a voir
Hold on, guys. Not happening. So. Damn it. Hold on. Something's frozen. Hold on, guys. I'll back it up a little. Let me get it out of here. We're going to back this up a little because what she says is
Particular
important.
Dog, particularly
Hold
in
on.
light of the most recent National Academy of Science report that found that
I'm going to go back just a smidge to hear what she has to say because he kept buffering.
conclusion, Your Honor, we respectfully request that the court deny the request of the Commonwealth to have a voir dire hearing on Lieutenant Wing. At a minimum, wait for that determination until the court reads the report
Right.
of Lieutenant Wing.
Right.
Thank you, Your Honor.
okay.
Watch this.
All right,
This is
so
funny.
there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration.
Not happening.
I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby's an expert.
Yep.
I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific
have-
dog.
The bite patterns. That's how.
I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the
Easy.
most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence.
So why are you
So
allowing
what do you
Dr.
want to say
Russell?
about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well-respected. I've read it many times. And that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair
He was
to
called in.
conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern.
That's right.
I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude
Yes.
a person or a dog as the contributor of that bite.
This
And
is
here,
the Crosby.
there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring.
Correct.
The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way
He's
to
right.
a degree of certainty that these wounds were caused by Chloe's mouth.
Nope.
In particular, Dr. Russell had opined not only that the
Yep.
bites were consistent with a dog wound,
Yep.
but she also opined about molars in different parts of the mouth.
Yep.
And since the defense
Wants to let her testify.
has
to that.
decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog,
And he has a right to rebut
we
that.
should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been
Right, there's no
caused
reason not to,
by
legally.
Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr.
Wow. That's a bias. Thanks, Bev, for that. It's an uphill battle. Why?
Thank you,
He's
Your Honor. I
100%
can go
right.
through this quickly. The National Academy of Science, the 2009 report Your
Argue
Honor is
against
referring
Your
to,
own witness.
there is
Do
no
it.
finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that
Oh.
proposition. That's
Oh,
number
okay.
one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even
Yeah, absolutely.
not
Sure.
considering the first
100%.
point I made, where that's allowed for
Discriminatory.
humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So
Really?
in
Yes, there is.
sum, the inclusion exclusion distinction that Mr. Brennan tries to make is
Interesting.
nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed.
Oh.
So we, Your Honor, would
Methodology.
support what Your Honor's question, comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or
Oh,
exclusion.
but you'll be able
basis.
to say
Thank you, Your
that
Honor.
it was her.
Did you
It
wanna
is
reply?
her.
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there being discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So
Bingo.
it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
God, I dare you to object.
No, Your Honor.
Okay,
Yeah, that's what I thought.
so Jim, 63 is allowed.
Yes, Your Honor.
Right?
So you
Chloe's new
both have
owners.
motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the
Right.
opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
One is actually a wig. I
Okay,
wish I could get good extension.
who's arguing this for the defense, or who's
would love
telling me
that.
what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right, I'd like to see what you both intend to use in your openings, because
Yeah.
whether you
trust
agree
me.
with it or not, I have to make sure that it's
Correct.
admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court, the Commonwealth will provide a copy to defense. That's,
Okay, thank you. Can I have the defense, what you intend to put up?
A single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay,
Your Honor, I'll add that there are a number of statements that we have clipped.
Oh,
We,
I
with the
knew
court's
this
permission, would
so
like to
bad.
provide an entire package to the court so you can have an opportunity to view if you wanted to.
thank you. So I need the defense to look at this before the end of the hearing because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay,
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive on what we intend to
We
provide.
have to elect.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look
I
at
want to
that.
go.
Okay, so that
So bad.
sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case.
Yep.
I don't expect there'll be any emphasis or drama in the presentation
Okay,
of text messages, but I think an independent reader is fairer,
Yep.
more objective, and we'd like
It
to
is.
have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
all right. How are you going to find this person?
But we could have somebody plainclothes from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay,
May I have a moment, Your Honor?
yes.
What the hell? Audio. Right? Like, come on, man. Some people don't want to come back tomorrow. What is with the audio? You just cut the audio? What the? Dude, you know, I'm getting real sick of this bullshit-talkie today.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name.
But they have
Mr.
them all.
Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
You don't
Go
know?
ahead.
May I?
Yes.
Come on.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively,
Okay.
we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what
the proper protocol is. If Mr. Greeno is the one who found, if he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that it is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're their statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a
Reno
female.
was in a car accident.
And that's
Actually,
exactly
he
what
was
we
hit,
don't
I
want.
think, by a
I think
car.
that's inappropriate. It's not going to be Mr. O'Keefe, and it's
I
not
wanna
going to be
go.
Ms. Reed. The text messages speak for themselves. The jurors should be able to
Somebody's gotta
analyze the
read it.
words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may
They
or
don't
may
have
not
motives.
be
They're independent.
consistent with the text
Idiot.
messages.
You're a
As we all
fucking
know,
idiot.
it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally.
I would love teeth
People
implants.
talk about it all the time.
Do it.
Things get lost in text messages.
Oh,
Having
please.
been read by a state trooper who found them.
So it can be perhaps, not a state trooper. That's all. I understood it to be
Independent is
to
fine.
take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen.
No,
And
please.
this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly
They had bite patterns for the first trial. Patterns,
objectionable.
bite
And then
pattern.
once it's
Not
done,
an
it's
actual
done.
full mold, but the bite pattern
All right.
different than a mold. They had bite patterns
I will
for the first
consider it.
trial.
There'll be no inflection. That would be inappropriate.
Thank you. All right. Defendant's motion for specific discovery,
Yes.
paper
They
638.
have a paw
Jimmy.
print.
All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not
No, we
agree
didn't.
are
We said bite
3 and
patterns.
4,
I
which are
specifically told you
related.
bite patterns,
I will
not mold,
say,
bite patterns.
as a preface, that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration.
What?
With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay. There's no authority for that in Rule 14, correct?
We
Nope.
believe that it's consistent with Rule 14, which is why we've made
No.
the request.
Okay.
Definitely not.
Where?
Yeah.
Where in Rule 14
No.
are the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility,
Nope.
motives, intent, and
Wrong.
that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Right. Dr. Russell for embarrassment.
Yes.
Green.
With regard to number 5, we
Embarrassment.
also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Yeah, like you didn't last time. Got it.
Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility.
Nope.
It is not within Rule 14,
Nope.
should not be discoverable, it's irrelevant. It doesn't show any bias on behalf of the witness. If they had any reluctance or concerns about testifying, I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right.
You're ruling against that
The
one.
ARCA witnesses, motions regarding that.
Let's hear it.
So
ARCA.
where do you stand, Mr. Brennan, with
Bingo. TB2.
what has been provided and what you might think has not been provided?
Exactly, LA.
There are 2 issues. There is the discovery that we have requested in the past.
And not gotten.
At this point, I stand unsatisfied with that discovery production.
Bingo.
And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery.
Bingo.
I'd like to start with the second part, and that
Yeah,
is
red herring, Aaron.
we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024.
Yep.
The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc.
Didn't get
And
them.
so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant.
Yep.
So if the defense position is not in their custody and control, and then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently.
No.
We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion
Aiden's
about the
girlfriend,
ARCA witnesses potentially
SD, and
rebutting or commenting on Mr. Welch's testimony.
Kelly Reed,
Discovery deadlines have passed some time ago.
Manson
It would
sisters.
be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Okay, who's happy with this?
I will not. I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion.
So bitch about
or certificate
what
of
the
completion.
Commonwealth gave you and didn't give you. That's not the
long
argument
ago,
we had here.
And we have
sir.
consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control.
This one isn't, though.
To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office of the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate there too. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think
you have email.
timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day.
Sure.
If we get new testing results, we will turn those over the same day that we get them.
Yeah, what about all your emails that you have?
The conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once they get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not
Your email, text messages, you
hiding anything.
as
soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith.
Email, sir. You avoid those things.
With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but.
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points they were?
I'm an ARCA, and they have those.
Because this is on what you filed. So this is not unusual. A party says we asked for all 13, another party says we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which
All of
of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed.
Yep.
And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November.
And here it
What I
goes.
expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all the billing, all the communications, all the text messages, all the emails
There it is.
between the parties.
Text message.
And if the defense's position is not in their custody and control, well, it's certainly in the custody and control of ARCA.
Yep.
We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Yep.
Okay.
And so
No.
my tolerance about this ongoing development of discovery.
They're
is an
hiding it.
extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So
That's
address
what we
number
You're
one,
lying.
please.
I
Okay.
am. That's
No,
what
you're
I'm
not.
doing, Your Honor.
No, you're not.
We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced
Nope.
and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is
What about Dr.
specifically
Sheridan?
in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over.
False.
There is nothing that we have not turned over that's in our possession.
That's not true.
With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera. We could not engage these experts until we got permission from
you
the
have now.
Department of Justice. The federal government had to give us
Period.
permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact our and engage them formally so that they
The
could
word he uses. Leapt into action. No, you didn't.
act as experts for the defense in this case in furtherance of potential testimony moving forward. We do
Very
not
whiny.
have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet
You have emails.
because it's only been
Text messages.
a few days.
Ah!
If we get those, we will turn those over immediately. And that's all we can be expected to do.
Oh, really? Not if
the
you're
court
hiding shit.
wishes to go through
The lies
the
are
others,
fucking
there
amazing.
are- it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with,
I have a question. It was my question last time when they testified. It wasn't clear to me who did what.
Yep.
What each witness did regarding testing, preparation, things that are
That's right.
normal cross-examination. Is that clarified any better?
Nope.
They said we. They talked about we did this, we did that.
well,
we
I would disagree with that. Dr. Rentschler talked about what he did, which was more on the
They
on
need
the
to know what Dr.
biological
Sheridan did.
side.
There was a difference between the
And
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific
We need to know what
capacity
Dr.
was,
Sheridan
their
did.
expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
They're going to keep arguing about whether they.
Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that is on. That's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential.
Right. Can I see counsel at sidebar, please?
She's about to ream him out, and I promise you, because she asked a million times, the judges asked numerous times for them to clarify who did what. It's not just about Rentschler, okay, and Wolf. It's also about Dr. Sheridan. The Commonwealth needs to know why they didn't use Dr. Sheridan, what his opinion was, because if Dr. Sheridan had an opinion that was different than the other two, they have a right to call him as a witness and ask him why. And if he disagreed, and why did he disagree? There is no clarification as to what each person in that report did, including Dr. Sheridan, the one the defense did not use. And clearly they did not use him for a reason. So he keeps trying to dance around the question. Like, that's why she's pulling him a sidebar. Because she's tired of the dancing around of the question. Like, answer the fucking question. Like, we need to know who did what. The Commonwealth needs to know who did what so that they can know if they need to call Dr. Sheridan as a witness. It can't just be we did this and, well, Dr. Wolf did this and Dr. Rentschler did this. It needs to be exactly all three of them and who did what, when, where, and why. Like, or they can't cross-examine. They have the right to that. They have the right. So ridiculous. Like, yeah, it doesn't make, that also doesn't make sense. There's something going on with that. I got to figure out what it is, but for them to make that request for her to be like co-counsel to the other attorneys, why? If Yannetti is already holding a license, there's no need for a second attorney unless you anticipate him not being on that team, there would be no reason. For what? Just for an extra, like, funding? Like, even the judge is going to be like, okay, for what? For what? Like, it doesn't really make any sense. This is going to be a blast during opening statements. No, but he was called in for a hearing, so maybe, I don't know, maybe he's waiting outside. It's possible, but I think that's why he's got his girlfriend in there, so she can tell him everything that happened. Unfortunately for her, if she gets caught telling him what happened in any way, shape, or form, they're both in big, big trouble. After the jury is, not right this second, but after the jury is sworn in and the case starts, she goes back and tells him anything about anything, having watched the trial herself. That's a no-no. As of right this minute, at least, he's not exempt. Interesting. This sidebar is long. Long sidebar. In the meantime, hit the like button, subscribe, share the video. If you can donate to the channel, that's always a huge help. We only survive on our donations from our viewers. You can do so on Venmo, Cash App, or PayPal. There's a ticker at the bottom right below this big thing right here, right below that. Boop. There's a small one with all the information so that I can pull the big one down. It's a good question, Anna. That's a damn good question. You know? It's a damn good question. See how many court officers are in there too? I count 3 that I can see. Got to be one closer to the judge at least. 4. I saw another one sort of stick their head in. Look at this person staring up at the camera as they try to get to where the jury usually sits. We see you. I mean, let's remember that the defendant here, team of goons, tried to raffle off a court seat, a public court seat, mind you. They can't save seats. They can't raffle off seats. If one of their actual family members isn't using it, it belongs to the public. It's really just that simple. It's first come, first serve to the public. The public has every right to sit in on this trial. So if there is a seat, it is first come, first serve. Like, right? That case is a shit show in and itself. In and itself. See another court officer? That's a 4th. Looks like he's walking behind everybody with computers. Probably smart to monitor what they're doing. I see Christina Rex. I see. Yeah, they don't need to be here for this. It's just motions. And, you know, I really hope that they are arrested because Tuesday is going to be opening statements and it's going to be a long 6 to 8 weeks for everyone. So this is definitely not something that they needed to attend. It's just motions. 1, 2, 3, 4 court officers. And there's got to be one closer to the judge. Usually there is. 100%. Most defendants stay in their chair when their lawyers go up. Not this one. That's why she wanted headphones, you know? Right? Wish I could. I would just cuz, but got mom duties. The cult is despicable to begin with. They troll, as you see here. Like, newsflash, bro. I would skip every single meal on planet Earth if it meant my kids ate first. Like, that's the stupidest thing I've literally ever heard of in my life. Never mind the fact that my kids are like all in the 90th percentile or 85th percentile when it comes to height and weight. They eat just fine. They make sure as a parent that happens. Yeah, you could. You could go and sit down. First come, first serve. Anybody can. It's public. It's open to the public. You absolutely could. And no invite needed. It's open to the public. Every court case is. It's a public trial. The public has every right to fill up all the rest of the seats that exist. If they're family, the ones that are exempt at least from any orders or anything. Look, there's Bradle. There's that slimy, sneaky, lying piece of shit. Order pizza from D&E. Deliver it to Dedham. Will you deliver to Dedham? Of course, that sneaky, slimy piece of human garbage is there. I hope the judge catches him lying. Nope, they're coming back to the seats. Let's see what happens. I'm confused. Why is Jess Giannetti over here? I'm confused. What is going on? Why isn't he up at Sidebar with the rest of the attorneys? Something weird's going on. Yeah, why is he packing his shit up? Here they come, but why did he come back before them? He's leaving? He's leaving. Why? Why? Oh, now George gets the table.
All right, so Mr. Jackson, you're saying that the ACA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise.
Not
Everything that
George
they
is still
did,
there.
everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report. And that was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti. And you have that all documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was
Yeah,
honored,
something's up.
as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of
I don't know.
Justice, or the U.S.
Something's
Attorney's
up.
Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were
All right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow,
Clearly.
it was a narrow scope of work, if you
Yep.
will, that did not include the myriad things that we were getting in NODs.
All right, then you
September
started
2022.
providing them information
Yep.
to fill in those gaps, right?
Once we received information.
Look at Elizabeth Lynn looking at him like,
Dr.
no,
Welch, for
no, we
instance,
didn't.
knew that we wanted at least
You didn't.
to explore the idea of rebutting some of that information.
You didn't, though.
From a biomechanics standpoint, and we wanted them to have basically a
They said
mirror
they didn't.
image of what Dr. Welcher was provided.
All right, so when
that's
did you
what
do,
we provided to them.
when did you do that?
I want to say March 26th or 27th.
So you just provided it.
I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26th, 2025. That same day, the defense was provided all the additional materials
Yeah,
to
you're right,
ARCA,
something.
including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I didn't say 3 days. I said, I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
Oh, now it's week or 10 days.
All right.
Not good enough.
We are
We're gonna have
acting
to give it
as
to you.
efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
They lied about.
Mr. Brennan, I'll hear you.
Lots, because they're going to lose and they know it. It's just about delay. Delay, delay, delay.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern In fact, that I anticipated this very thing would happen.
Yep.
When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never. But it was to preclude the defense from trying this case by ambush.
Yep.
And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure.
Yep.
Regardless of whose fault it is, I still do not believe we have full disclosure.
Don't.
Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion
Bingo.
for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable.
Yep.
That information should come directly from the ARCA witnesses if the defense can't or won't produce it.
Yep.
I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled.
You are.
The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute,
Delay.
then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement.
No.
It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses.
Nope.
They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November.
Yep.
We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders.
Yeah,
we
period.
provided the discovery pursuant to the orders so that they would be held to the same
Mr.
standard.
Reed looks stressed out.
And now we hear they waited until February 7th, 2025 for a tour request.
Come on.
And now they're giving new information to ARCA to come back
No.
and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing.
Right.
This is the core of preparing for the case. They had that obligation.
And they didn't do
And
it.
so now to
on them.
allow them to do this, it's not an aberration. This is a continued pattern from the last trial.
Yep.
They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules
No.
and come in tomorrow, the next day, or 10 days from now
No.
and have
No.
new opinions after
No.
we've already told the jury our theory and our science and not have a chance
To rebut there.
to rebut it or consider it?
No.
I'll have no time during trial to sit down with the experts and assign them to review new information, new reports.
That's right.
I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this
That you
case
might
and
need.
scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point,
Yep.
the defense has to be held to the same standard of discovery
They do.
obligation. This isn't late notice. This isn't parachuting in. This is an
Yeah.
effort they decided to make and wait until March but February 7th, 2025.
Yep.
Your Honor, I ask you to allow ARCA to testify, allow them to testify
To what they
their
already have.
report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
She's going to have no choice but to do it,
Your Honor,
unfortunately for the defense.
what appears to be feigned indignation is just not
Feigned? Stop it.
consistent with the facts.
With the pearl clutching, sir.
We didn't
Stop it.
receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet.
Yeah,
There is
stop
no
it.
ambush. This feigned indignation is just not consistent with the facts, Your Honor.
No, but
the
it is.
court hadn't ruled that we could even use ARCA until just a few weeks ago.
Oh,
we were
please.
moving expeditiously to try to rebut
Please.
a
You would
witness
still prep
that
your
the
witnesses until then.
Commonwealth
Stop it.
disclosed in February of 2025. By mid-March, we were finally, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some
Bullshit is right.
advantage. As soon as we got the request
Bullshit.
approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them
I know the judge isn't even buying this.
at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander.
Exactly why she's going to have to hold
Mr.
you
Brennan
accountable
has
for not
been
meeting it.
consistently
Sorry.
providing us with new discovery after his certificate of compliance has been well done, the ink is well dry.
Because you keep asking
We have a
things
right, we have an obligation
that aren't part of that.
to address
Bring
and
them
to
anyway.
meet his new discovery.
No,
For
not new.
instance, Judd Welcher's opinions and
Not new.
conclusions, with rebuttal opinions and conclusions, if we
Not
can.
new. And so do they.
And I want to make sure
So do
that
they.
we're not conflating
You're arguing
two
against your
separate
own
issues.
argument.
One is
Dumbass.
the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the
Thanks,
communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know
course.
what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly
Bullshit.
nobody is at a disadvantage in this trial.
Bullshit.
We're simply trying to meet our obligations as we could
You're not.
within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted.
You want the judge to believe
And
it's
we're moving
amazing to
forward
me.
as expeditiously,
In California,
as
bud.
expeditiously as we possibly can.
This is Massachusetts. The judge ain't even buying that, I promise you. There it is. Do it, Hank.
Rather than addressing their obligations, it's always an attempt to assign
Point
blame.
fingers.
The government or the Commonwealth gave us late disclosures.
Yep.
The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report.
That's it.
There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
Nope.
According to Mr. Alessi, who is much more facile with the facts
Oh,
of
please.
what's in Judge Welch's report, that's not quite true.
They did.
There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information
You had
from
most
Judge
of it,
Welch.
bro. Stop it.
The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage.
You could have hired
ARCA.
anyone.
That's when we provided
Could have hired anyone.
the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no
There is.
attempt at taking an advantage
course there
vis-a-vis
is.
time. It just doesn't. The arguments just don't play.
They do.
Not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you.
He knows he's going to have to
I think is the only thing left
come down on the defense.
the motion to sequester Aiden Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes. Where do we stand with that? I thought that you were going to
Talk to each other.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible.
No.
It's an opinion of a third party.
Yep.
And then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that.
Of course you do.
Assertion. That's not the state of the law. We
It is?
did provide notice to the Commonwealth of what we intended to admit at trial. Commonwealth was conversely ordered to notice what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right. So I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that.
The judge, too,
Do you
dumbass.
have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know
No.
what? I do need that in writing.
Yep.
I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we
Yeah,
allowed
okay.
to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
Um,
You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out
Yeah.
what the objection was and what you wanted to put in. All right, so we need to take a recess anyway, so
Why?
that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute
Ugh,
recess?
Come on.
And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
That's obnoxious because, as we know, their 15-minute recesses are usually more than fucking 15 minutes. Like, so he's seeking to have himself exempt from being sequestered as a witness. That's what that means. They want, he wants to be exempt from being sequestered as a witness. I don't think that's going to happen. If it does, shame on the judge. But once again, we never know with her, you know? Never know. Yeah, that's what I'm saying. Like, you only been at it for 90 minutes, bro. You're in recess. Like, I get it. They need to see a video. Cool. That's great. Like, right? It does remind me of like hopscotch, kindergarten, and chalk. Reminds me of chalk. Does anyone remind you of chalk? Say recess or kickball. Like kickball when you're a kid. Like, I want to look. I find it funny. No, he's not asking the judge to not be a witness. He's asking the judge to allow him in the courtroom while he's a witness. The witnesses are not allowed to talk about the case, read about the case, watch the case, or be in the courtroom during the case. That's why they're sequestered until they testify. He wants to be exempt from that. So, yeah, she does. We never know with this judge, but that's essentially what he wants to be exempt from. He wants to be exempt from having to do any of that and be allowed to sit in the courtroom for the case. His argument would be like, oh, it's my job. But the Commonwealth's argument is going to basically probably be, well, if that's the only job he has as a media personality, there aren't any other cases he can cover. And also maybe he shouldn't have made himself part of the damn case if he didn't want to testify. Just saying. Just saying. Like, that's what it boils down to. You know what I mean? Like, you're totally welcome. Yeah, I'm trying to figure this out, right? I've lost quite a bit of confidence, but I have to believe that, like, she does the right thing here, you know? She's the one in red, Anna. She is the one in red. I have a $5 sent from LA. Thank you, LA Connection. I appreciate you, my friend. If anybody else wants to donate to the channel, that is how we survive over here. This is the information to do so. You can also like, subscribe. That also helps. Sharing the video helps. We don't have we're smaller than other channels, so we don't have super stickers, super chats, memberships, all that stuff. I reapplied for it, and YouTube is very slow when it comes to that. So until that happens, hopefully sometime during trial it will. That's the only way I can take anything. And it definitely helps for sure. And I appreciate it from you guys. Yeah, she is the one in red, Anna. So here's the question. There's a ticker at the bottom of the screen, right below where that one just was, for any information for donations, in case you guys are wondering why I pulled it down. Right underneath this bubble where Freak's name is the ticker. That has all the information on it. Please do, Jack. Please freaking do. Like, the fact that they allowed these people to, you know, attack my channel, like, with fake reports, like, that's just obnoxious. Like, and, you know, for me, it's like the bigger channels with more subscribers didn't have that problem. So it's like the bigger you are, the less YouTube takes into consideration when it comes to fake shit like that. It's just annoying, you know? Right? I had 3 membership tiers. Twisted Trooper, Twisted Sergeant, Twisted Chief. We had 3 membership tiers. It was fun, you know? All right. So here's the thing. What the hell is going on with David Yannetti is my next question. He packed up and left. All right. So I'm confused here. I feel like this has to have something to do with why they're asking for Victoria George to be holding these licenses. Why? Is he not going to be here for trial? Is he not going to be here for some of the trial? What is going on? It just doesn't make sense. You wouldn't ask for another attorney to be holding the licenses unless you weren't going to be there. Maybe he had to testify somewhere. Maybe he had a case. I don't know, but something's going on, whatever that may be. And I need to figure it out because that's weird. She works for his firm, so it's not that, I don't know, it wouldn't make sense if he was just taking himself off the case completely because she works for his firm, right? She's working for him right now. So that's weird. Like, oh, good. Christina Rex must have saw. I said to her, there's no audio. When we first got into it and there was no audio, I said, Christina, there's no audio. So hopefully she walked up and told someone because she said there's sounds working now. So she clearly must have seen that I said, like, hey, there's no freaking audio, man. Like, but I'm looking to see if there's something that tells me what's going on. The hell? She said we're working on it. It appears there's a sound issue for the distribution system, should be fixed soon. So that's like before they fix the audio. I don't see anything about why. That's the weird part. Like, I don't see anything that anybody, I've reached out just to see if anybody can tell me what the hell is going on with him, because that's really strange. Like, let's see here. Let's see. Jackson's still playing fast and loose with Arca. Yeah, shocker. Let's see. Guy should be tossed out of court for his repeated lies. This is Boston, not LA. Guess I wasn't the only one thinking that, John DePetro. I was not the only one who was like, this is Boston, not LA, sir. Like, guess I was not the only one thinking that. I mean, that's immediately what came to my brain as he stood up there and lied about Arca. Like, dude, this is not LA. This is Boston. Like, this shit ain't gonna fly. Like, sorry. I see nothing, but I find it very strange. Something is going on with him. Something. I have no idea what it is, but something. Like, let's see. My God, there's somebody trying to cite laws to me that have no idea what that law actually means. Like, other podcasts heap dissing Massachusetts and the judge. I can understand people being frustrated, but it's very aggravating to hear people in states giving shit to Boston. Yeah, it is, especially since we're a bunch of strong people here. We actually do have intelligent people here in Boston. Unfortunately for us, we're seeing the stupid side of it when it comes to some of these people who support Karen. But I promise you, there are a lot more smart people here in Massachusetts than there are in most places. I mean, think about it. We have some of the best hospitals in the world. That tells you we have some pretty goddamn intelligent people. Just saying. Like, I don't know. Not that I know of. An order? I don't think that would apply. He's an attorney in the case. So, I mean, he's arguing a case. So I don't think that would apply. You know what I mean? If somebody else had an order and came into the court, he wouldn't be told to leave. If he's doing his job and he's there doing his job, that's like somebody going who has an order on you coming to your job. That wouldn't, you know what I mean? That wouldn't make sense. I don't know, Trish, but I'm going to find out. I intend to find out. You know what I'm saying? Like, and also these podcasters who don't live here have no friggin' idea what they're talking about. And half of them, even some of them that do, like, we're not talking about the most brightest of bright when it comes to these other people, dude. You have to remember, they spend, 50% of their time reading super chats and super stickers. Like, I say my quick thank yous. I try not to let it take up the show, and I don't get that many. So, you know what I mean? Like, there's no reason to be spending 50% of the time reading super chats and super stickers. There's plenty more people in your chat that want to be heard. Like, you know what I mean? Yeah, I did say that he'll remain as lead counsel, but something's fishy. Something's up. I don't know what it is, but something is weird. Something is off. Why ask for that? You know? Oh, no fucking way. Shocker. Shocker, guys. Shocker. Amazing to me. It's absolutely fucking amazing. Like, I literally can't. You know what, though? Like, well, that's the thing. Most of them only read those, right? Like, dude, there's so many other people that like are watching you and want to be heard. Like, take some time to read some of these other people. Like, come on, man. Yeah, like really. It's like they don't pay attention, or they only care about the super chats and super stickers. Like, I mean, yes, you want to show your appreciation. I get it. I do too. But at the same time, like, what the actual hell? Like, Something's going on. Well, I wouldn't blame her, would you? I wouldn't blame his wife, that's for sure. I would not. That poor woman, the shit she's probably had to put up with when it comes to this stuff. Like, ay, ay, ay. Like, it's just insane to me. Like, they are playing dirty, as we know. And Hank was right. This is something he's been bringing up for an extremely long period of time. Since the very beginning of him coming onto this case, he's been bringing something like this up with them dragging their feet. He's right. They could have hired anyone. They didn't have to wait for ARCA until the last minute. They could have hired any expert anywhere else. They waited and waited and waited. Why are you providing them all of the things now? Also, if you provide them with all the evidence and their opinion doesn't change, that's a fucking problem. Like, that just makes them not credible to begin with. I'm just saying. Text stream data and everything else. Like, come on. If they didn't automatically change their opinion and say, you know what, now that we have all the data, we can't say that he wasn't hit by that car, that they would be taken off the witness list. Well, they might remain on it for the Commonwealth, but not for the defense. So the fact that they're not, okay, speaks volumes to me. That means that they're going to double and triple down. Like, no worries, Anna. It is. It's a conversation between a bunch of people who want to know answers to questions. And that's how I run my show. Not just for what I have to say, but for what you guys have to say, because there's often very intelligent points, things that some of us might have missed that someone else brings up, good points of view, good things to debate. Like, I think creators lose out on that when they don't delve into their chats and their communities. And that's just my opinion. But I feel like they lose out on that. That sort of community of things that people have to say, and you're missing out on really great points and like really great things that people have to say by just ignoring everyone except for your super chats. It just doesn't make much sense. Like, oh, they're definitely hiding stuff. The judge has to stop letting them get away with it. That's the bottom line. And obviously we do not have full confidence that she will, but I mean, this is a pattern. It is a freaking pattern of behavior with them. This isn't something they've tried once or twice, okay? This is something they've been doing for quite some time now. They're not just going to magically stop. Like, delay. They tried to get this trial delayed from 3 courts. All the courts said no, F off. So clearly they're going to do anything else to make it delay as well. Like, I mean, if it couldn't be any more clear to the judge, literally, you know? Exactly. The only dumb question is a question not asked, you know? Yeah, that should make everyone mad, Trish. You know, interview where she says she didn't hit John, but like she can't make it sincere enough and she's smiling. Like, that is some psychopathic shit, bro. What is funny? Like, first of all, you wouldn't have to make anything sincere if you were actually sincere. Isn't that about a bitch, right? You wouldn't have to make it sincere if you were actually sincere in telling the truth. See how that works? But she's not. Therefore, she has to attempt to make it sincere. She told on herself. She dry snitched on herself by saying that. Like, I can't make it sincere enough. Well, I mean, yeah, because you're trying to make it something. You shouldn't be trying to make it anything. You know what I mean? Like, there should be nothing that you're trying to make it. Like, it's just crazy. Like, well, that's another thing. The fact that the judge allows them to get away with it is why they continue to do it. You know, like, I've never seen a tear. I've never heard her go on about how much she loved John or how much she misses John or how awful it is to not have him around and all the things she misses about him. Not a single thing. Not a single thing. And that speaks volumes to me. That's my opinion, of course. You know, other people might not have that same opinion, but that's my opinion, you know? Well, that's the thing, right? She is paying so much money for her to say nothing because we know she's not getting on the stand, right? But to say everything she wants to the media. She said yesterday to the media that she would not, you guys are going to love this one if you didn't see this. She said to the media yesterday coming out that there's nothing that she has said to the media that she wouldn't say again. And you can bet your ass that Hank is going to try to use that. I would if I was him. That's for damn sure. I would absolutely want to use that. And that's the thing. The only time you might see them cry is when Karen's held responsible and found guilty. Right? And then that would have nothing to do with John, but to just be sad that their smear campaign of anybody who speaks the truth ultimately ended in a failure for them. You know? Yeah, the thing she says where she's like, they were just dating. So what? Because you weren't married, you didn't love him? Make that make sense. You're with him 2 years. And at one point, Lisa, that was a headline. Happiest murder defendant in America. It was a headline. What does that tell you? A headline from a news station was happiest murder defendant. That, oh, she was just dating John, right? So why would you be upset or mad or sad? Because they were just dating, right? Like, I'm sorry, I didn't know just dating means that you loved him less. It's like, what the hell? Oh, yeah, it'll be big waterworks, fireworks, you know. I mean, it's very possible. I know he was definitely sick of her shit at the end there. We know that. We can tell. We can tell that he was definitely sick and tired of it. He was done with the arguing every day, according to him. You know? That's the sad part. It's really, really sad. Everything that he had to go through in all of this. Ultimately, to lose his life at the end, you know? Mm-hmm. Somebody's saying they are watching the trial from England, and it's been hard for them to find a channel like mine. Who are rational and honest, and that seeing that the Karen Reed circus play out, it's like watching a crappy B-rated movie where the actors are amateurs and the plot is too far-fetched and the script keeps changing. You nailed it. It's sad. It's really sad. And this was on yesterday's video. The comment that was just left about 2 hours ago was on yesterday's video. I do believe. Yeah, we all know, right? We all know who did it, Steve. We all know, and then we don't know. It's not for us to know. Remember that one. Back to they know. Yeah, because that definitely makes lots of sense. I do believe he will end up in front of the California BBO. Is the BBO ever really do anything? No, which is why they need to be replaced. Lawyers can't look into lawyers anymore because clearly they don't do shit, and that's a problem. If Bradel doesn't lose his law license, then I guess we can all kiss the BBO goodbye, because for the information that he held on that case, he absolutely should have been, his law license should have been pulled. But you almost never see that, and that's a problem. These kind of egregious things deserve their law license to be pulled so that other people know, never try it again. You know? Of course, they'll say they'll fight it. I mean, they'll appeal and appeal and appeal, but at least it won't be in the news anymore. People won't be talking about it anymore. Most people won't give a shit anymore. She can appeal until the cows come home, and she can sit in jail while she does it. Just like every other murder defendant. You know? Yeah, that makes me sad too, to think about him being there by himself. Nobody should have to pass that way. I can only hope that he was knocked out and didn't feel anything. You know, that's the best that we can hope for at this point, because to think about if he was awake at any point but just couldn't move or couldn't get help because of the head injury, that kills me. Like, that's, no one should die alone in the cold, you know? If I had a time machine, I'd go back. If only, right? If only we had time machines to just go back to certain points like that and stop things from happening. But then again, I think about all the damage she did to those kids, and I'm like, she deserves this trial. She would have hurt someone else in the long run anyway. Her history with reacting and men is not good. I wish the ex-boyfriends would come forward, but you know, they're not going to. They don't want any part of this shit show, and I can't blame them. None of us really can, you know. I'm sorry. I have tissues. I wish I could give them to you through the screen. Yeah, they are pretty sad. Like it's the whole thing is just heartbreaking. Those kids have been through more than enough that any kid should ever have to go through at that age. I see the camera moving. Yeah, 20 minutes and counting. Exactly. What the fuck are they doing? Their 15 minutes is never 15 minutes. Let's just make that clear. It's always 20, 25, half hour, you know. Well, that's the thing. Not only do they have 6 lawyers, but they have like 10 law clerks. There's no reason they should be unprepared. None. And this is the point that the judge should be making is you have more than enough fucking help to get all of this done. They're hiding the emails and the text messages between them and ARCA. We know they exist. We know they do. By them just saying they don't exist, I mean, that's what lawyers like Ellen Jackson do. They don't exist, so we can't give them to you, Your Honor. We can't give them in discovery because we don't have such a thing. We know they exist because the emails that we already know are there. So clearly there's an email before and after those ones and in response, you know? Oh, yeah, when she's finally brought into cuffs. I mean, daddy, 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 crying a river. Well, he's not going to be able to do much for her. Her parents are elderly. You know, how long do you think they'll be alive? Hold on a second, guys. The glove came. The media circus is ridiculous. Just ridiculous. It was a simple auto pedestrian accident. Then the defense made up a story and propagandized the public. Well, that's exactly what happened, as we know. It's all the stuff about the dog is literally purposeless because it has nothing to do with anything. There was no dog involved in any of it. Like, and if the judge wants to, you know, sort of limit the testimony of one of the Commonwealth's experts about whether they can prove that it wasn't Chloe or not, then you also need to limit Marie Russell saying that it was. See how that works? You absolutely can preclude it with the molds because the spaces between the teeth. So how wouldn't that preclude it? How wouldn't it? You know what I'm saying? Like, how wouldn't it? That made no sense to me at all. Like, no, nobody should die alone. No one. Yeah, John's friends gets me too. Yeah. I think lots of people have been with a narcissist before, myself included, and they're not fun people. They blame the victim always, smear the victim because they're hiding what they did. You know? Yeah, that's probably a good idea. I get being open to the public here in mass in over the country, but I mean, some of this shit needs to be precluded to be allowed to happen, you know? I'm coming, Elizabeth. Oh my God, right? Court's back. What do you mean? I mean, it's on the screen. Hold on.
You think about that? Okay.
Here it comes. Yep. It was around there. It was March. I didn't have
so
to.
the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that it's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
okay,
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to
For
discuss
what?
that. I'm not as concerned in
nothing to
terms
do
of
with it.
timing with that particular issue.
okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay, can we address, is it something you need for your opening?
It's not.
Okay, all right, so yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay, so now is the
Kevin Albert
only
has
thing
nothing to do with
left,
anything.
the
He
motion that
wasn't even
Mr.
part of the
Bradle's here
investigation.
for?
So that's
As far
weird
as I know.
to me.
Okay,
Very strange.
all right.
Very
Morning,
strange.
Mr. Bradle.
Good morning, Your Honor.
Well, morning, Mr.
Okay.
Dwyer.
So,
He left, and we don't know why.
Jim,
Go
you have that.
We don't know why. You been in the bushes the whole time?
All right, I probably have it here too.
There's no reason for them to even talk about Kevin Albert. None.
I have one, Jim, thanks.
Makes no sense.
All right, I will
hear it.
hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on
Yep.
all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit.
Yep.
If there is, Mr. Kearney becomes a more important witness.
Yep.
And we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Bingo.
All right, now I'll hear you, Mr. Bradle.
All right, thank you very much, Your Honor. Judge, we don't
Good
have an
job.
offer of proof.
Wah, wah, wah.
I'll try to argue
Please.
in the interest of time, and I think I know where the court's going with this,
Tuesday.
based on the prosecutor's
Tuesday.
statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Carney, who for the record is in the second row here today.
Bullshit.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute that seeking
matter
to
what you think.
contact witnesses, seeking to question people is witness
Okay,
intimidation.
so just focus back on,
So the answer is yes. I'm sorry. The answer is yes, Judge.
She doesn't care about your
Okay.
narrative.
so let me hear from you on that, Mr. Brennan.
He only knows
Sure.
how to do narrative.
Your Honor, under the government's interpretation of
Mr.
this
Brennan,
statute, Your
not
Honor,
Mr. Bradle.
the
Idiot.
the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan, and you.
Oh, I'm sorry.
But that's okay. I don't want to hear about
Got
the witness intimidation statute, other than
Yeah.
if I
No narrative.
don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and, I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. And now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Nobody wants to hear narrative, and that's all Bradel knows how to do is narrative, and that's not part of an argument. Narrative.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
That's right.
Do you need that to be done formally, or do you want it to be done formally?
I do.
Yep.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
I knew it. Called it, you guys. I called it.
Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right.
Told you
Mr.
guys
Bradel, why don't I
they
give you
can
10
take
minutes
it
to
and do
talk
it.
to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Do it. Do it. Do it. This became the best day ever. I'm just saying. And I always approach these things as if I was Hank Brennan, right? If I was Hank Brennan, what would I do? I would make him get up on the stand and take the Fifth Amendment. Period. Take it. Because otherwise it's just a threat. An empty threat. Is he really going to take the fifth? He's going to get up there and plead the fifth? Or was he using it as a ploy to not have to be a witness? So what's happening is the judge, Mr. Bradel, Aiden's attorney, who's just a bull-faced liar. Let's just throw that out there. The man is a liar, a snake, and is up against the BBO right now for things he's done in a different case. But he's basically saying that the sewer turtle will take his Fifth Amendment. He doesn't want to be a witness, and he would just plead the fifth to all the questions, right? To not against criminalizing himself with the answers. So that would be the Fifth Amendment. The Fifth Amendment is you're basically saying, I plead the fifth, I plead the fifth, I plead the fifth, which means you're not going to answer the question because if you answer the question, you could incriminate yourself. Okay. That's what the Fifth Amendment means. So, of course, his attorney gets up and says, well, my client's going to plead the Fifth Amendment, so there's no reason for him to be sequestered, right? Okay, cool, great, wonderful. All right. So Hank Brennan's like, okay, well, if he pleads the fifth, then I would have no reason to use him as a witness or for him to be sequestered. But he's going to have to plead the fifth. And of course, Aiden's attorney gets up and says, oh, I could do that on his behalf, right? No, you can't. He has to get up there and actually plead the fifth. So now Hank Brennan's like, no, great for your invitation, Mr. Bradel, but we'll have your client come and actually plead the fifth, because otherwise it's just an argument that he will plead the fifth. I'll say he'll plead it. No, make him plead it, right? Right. Don't walk the walk, just talk the talk, do both, right? So at this point, Mr. Bradel has to go back to his client and ask, Mr. Kearney, sorry, I failed. Do you want to go take that Fifth Amendment now in front of the court? Your Fifth Amendment right not to incriminate yourself with questions so that you look like a fool, or do you want to back out and just be sequestered? And we'll see which he chooses. He knows if he gets up there and actually pleads the fifth, that he'll get the same treatment that he said that the Alberts and McCabe should get if they pleaded the fifth. Now, listen, when you plead the fifth in court, it can't be used against you because you're just saying I won't answer questions because I could incriminate myself, right? They can't use that against you in any way that you're pleading the fifth. But I can because I'm not the court. And he was going to smear the witnesses if they pled the fifth on anything, which they had no reason to, obviously, which is why they didn't. So we shall give him the exact same treatment that he was going to give them. Go ahead, Aiden, plead the fifth. Dear Your Honor, I'm about to plead the fifth. I don't want anybody to know about my crimes, my very serious crimes. This is plead the fifth now. I, Aiden Kearney, I'm going to plead the fifth, Your Honor, against my crimes, so that nobody knows about my crimes. Thank you. Like, no, the jury will not know. And they can't technically use him as a hostile witness because if he's not a witness. So this is going to be a little, proxy pleading is not good enough. He has to actually get up there and plead the fifth. Brennan could ask questions that wouldn't incriminate him. See, that's the tricky part. Whether they just allow him to plead the fifth on any and all questions, or whether they have him, Mr. Brennan, ask all the questions and him say he's going to plead the fifth, and then Mr. Brennan argue, well, that's not a question that the fifth applies to. I don't know. We'll see. If he pleads the fifth, he could cover the trial, but he's not allowed to be in the trial or the court while the witnesses who have stay away orders from him are there. So Chris Albert, Colin Albert, the minor children, the O'Keefe children, Julie Albert, Nagel, Proctor's wife. There's quite a few of them that he wouldn't be allowed in the court when they're there. He wouldn't be allowed there because they're stay away orders. If there's a second grand jury on the witness intimidation, then he could be indicted for that as well. But that would be separate and apart from all of this. There very much could be a sealed indictment we don't know about. But I say, make him take the fifth. This day just turned amazing. Let's do it. For all to see and replay forever and ever and ever. Assert that Fifth Amendment privilege, sir. Please. I thought he said that he was gonna, Spanky wasn't gonna get him. He was gonna dance around him by answering the questions, right? He was gonna make Hanky look stupid, right? That's what he said. He was gonna make Spanky look stupid. Well, looks like he's the one making himself look stupid by pleading the fifth. But please, sir, by all means, plead the fifth. Plead the fifth. Unfortunately, yes, but there are parts he won't be allowed into because there are stay away orders. Right? It's hilarious to me. He has to plead the fifth to every question. Every question. Well, that's the thing. If it wouldn't incriminate him, then the fifth wouldn't apply. Right? They have stay away orders. Most of these witnesses, not all of them, but a bunch of them have stay away orders. So he won't be allowed in when they're there testifying at all. Right, Ash? Repercussions? I'm not sure there's repercussions, but right? We also can just hope that he doesn't get picked for the pool too, and that he's just a backup. Yes, they should, Inc. Completely held accountable. Right? We can play that one real quick. This I think we got a super chat. To be fair, you guys, I called this, okay? And like I said, I try to apply everything in my brain. If I was Hank Brennan, how would I do this? And this is something I called. This is something I knew that I would do if I was Hank Brennan. Obviously not 100% sure whether Hank would do it, but I knew that if I was Hank Brennan, I would make him get up there and plead the fifth. And I will take a bow for calling it. Thank you very much. I knew it. Hank is brilliant. This is exactly what I would make him do. Put your foot right in your mouth. Please. Well, it's not helping Karen Reed's defense. It's actually helping if he pleads the fifth, because otherwise he can incriminate her with his answers. I'm going to rewind. Don't say anything good. I cannot. I cannot agree to that, ma'am. I cannot, I cannot be responsible for all the things that fly out of my mouth. I cannot. You know this already, Anna. You've been with me long enough. You know that I cannot promise such a thing. Yeah, he can't use it to protect Karen. It has to be make it criminal to him. So you can't just plead the fifth if it doesn't apply, right? Give me 1 second, guys. I gotta grab my other vape. This one just died. But I love your stinking faces. Just give me 1 second. And in the meantime, if you want to hit the like button, that would really help. There's 230 of you. There's quite a few of you that could hit the like button or the subscribe button if you haven't already, or donate to the channel. The information's right there. Ashley put it in the chat. I'll be right back. Sorry, I need to grab this guy. Let's see here. Yeah, back down or step up. Back down and keep sequestered, or plead the fifth to every question. I do. I love you guys. Best day ever. Plead it. Plead it. It's like Jerry Springer. Plead the fifth. Plead the fifth. Do it, you fucking vagina. Do it. Do it. Do it. This will be the best clip ever. It'll be all over the internet. I hope he does. Let's do this, bro. I'm totally ready for him to plead the fifth. Let's do it. Plead it. Plead it. I just want to make sure real quick there's nobody I need to thank in donations for today, because for some reason my Cash App and Venmo haven't been telling me at the top. I've had to go in and look. Exactly. Chicken shit. Afraid. As he should be, to be fair. He should be afraid. Hank would wipe the floor with him, so I'd be afraid if I was him too. Just saying. Let's see. Nope. What's happening here? Nothing on Cash App, nothing on Venmo. No, they don't. Nothing on PayPal. Just making sure. Yeah, it is, right, Joy? Like, it just is. Like, and that's the thing, right? Like, she's using him, so it's like not out of the realm of like, he doesn't even, like, he's so stupid, dude. Please plead the fifth. Please do it. Do it. Oh, well, that's the thing. They need to wake the hell up. Time to wake up. Yeah, he gave them, yep, that's what I just said. He gave them such a hard time that, oh God, if they pleaded the fifth, that would just show that they have something to hide, right? Because why would you plead the fifth unless you had something that could actually get you charged, right? So anybody else get there? I got one eye watering. The windows are open in my house because it's nice out, but I have one eye watering and one nostril running from the fucking pollen, dude. Like, I don't think they will. That's the sad part, Trish. That's literally the sad part. I want to itch my eyes so bad. And I can't because my makeup, it'll be all over my face. But it's so itchy. I just got allergies like for the first time like 3 years ago. And it's not fun. I don't like the itchy eyes, the watery eyes. This is like a new thing for me. And I'm not a fan of it at all. I never had allergies my whole life. But now I do. See, I knew I was going to mess up my makeup on that. No, it doesn't affect his phone records. They still have those. But yeah, I mean, that's the thing, right? Like, how dare he say something about them? He never, you want to know why? Because he never in a million years thought that he would have to plead the fifth. That's why. He never realized that this could happen. So it's not just me. Like, it's not just me, Scorpio. Like, my eyes are so itchy. Like, that's the one thing that gets me is my nose gets running and then my eyes get wicked itchy. And like, I am not used to the itchy eyes. Sometimes it's both of them. Sometimes it's one. Today it's this one. It was like watering. I also have contacts in, so I can't just like itch it like this. You know what I mean? Like mess up my contacts. Oh, my phone just died. Hold on. I got to get the charger. Damn it. I can't read and thank donations if my phone is dead and it just completely died on me. So sorry, but I needed to go run and get the charger. Not that today's a super day for those anyway. I can't believe I've been here 4 hours already. I know, the 10 minutes has been up. Like, come on, Kanoni, let's go here. Oh, I love his videos. Matt's videos are awesome. Speaking of which, I gotta tell him. Can't tell anybody anything right now. Because my phone just died. That's what I am hoping that people do, is do some great clips of when he says that about them, which I know people probably already have saved and ready to go, because his attorney said he would plead the fifth. Okay, cool. Make him do it. Make him do it. Because it's one thing to say it. It's another to do it, right? Look, I literally have one tissue for my nose and one tissue for my eye. One for my nose and one for my eye. Oh, Matt always does. Always does. It's so funny to me. Like, get you with your own words. Literally. Like, yeah, I know that person. I know that person. Who knows? Ugh, I do. I do, Arlene. I really do. I don't drive. I don't have a car, so it's harder for, you know, when I gotta go somewhere, I have to Uber or Lyft, and unfortunately, I had that person has reached out to me. I've spoken to them a few times now. I honestly have no idea how all of this man's victims find me and reach out, but I'm glad that they do, because at least they know that their information is safe with me. And this is just one of many people who have reached out to me. This being a little bit different, though. This situation being a little different than the other ones. Yeah, I mean, they could definitely still use them depending on where they're bringing them in, especially if it's with the lawyers, because if the lawyers are going to stipulate to the fact that they're real and true, instead of testifying, then they don't need the other party, you know? Oh boy. I didn't see those yet. Yes, find it. Find it. Find it. We'll play it right after he pleads the fifth. Plead the fifth. Plead the fifth. Like, let's do it. Let's freaking do it. Turning my phone back on now that it died. Aw, I know. Poor thing. It's just awful. It's awful, awful, awful. It's literally awful. Like, some of the things this man has done to many, many, many victims, including people that are very close to me. is horrifying, disgusting. He should be in jail for the rest of his life. I mean, up.
You are unmuted.
Here we go. Plead the fifth. Plead the fifth.
Court is back in session. You may be seated.
Why isn't it charging?
Hi, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Carney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like
Yes.
Gary to consider his Fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at Sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tory and Chris.
No, we want to see him plead the fucking fifth. God damn it. That's bullshit. Come on, dude. I don't know if she's just doing like a sidebar thing. I mean, she asked Mr. Brennan isn't there. He's going to have to watch him plead the fifth. So I don't necessarily think he's pleading the fifth right now. Either way, even if he does do it and we're not watching it, it's still happening. Oh, come on. The audio's off. It's like, what the fuck? Like, we have a right to see this shit. I don't know. I feel like she wants to see him at Sidebar, probably about the specific questions.
Tory, Jim?
Yes.
Okay, they're done at Sidebar.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who have who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the two minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the
Oh.
last trial.
No.
Don't need to make any
Oh,
further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy
And it is something that we've done.
right, understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All rise for the court, please.
Well, that's that. The judge should have made him plead the fifth in front of everyone, like everybody else who's ever had to plead the fifth has done. He won't be allowed in there with the people that have the stay away orders, so he still won't be allowed for parts of it like he wasn't last time. But come on, dude. Like, what the fuck? Like, there's no reason that he shouldn't have to assert it in front of everyone. I can't, my phone's dead. I'm trying to turn her on now. One of my chargers isn't working, which is so fun. So I'm working on it. My really slow one I just plugged in. I don't know, Arlene, but it's really, really frustrating. Like, not only we're talking about different privileges, the man should have already been arrested for at least 10 other crimes at this point. Okay. And he hasn't been. It's getting extremely frustrating in this fucking state for people to just be doing what they want instead of what every other defendant and every other person in any of these situations have had to do. If it was me or you or anyone else, we would have all had to do it. Like, you know what I'm saying? Like, it is a distraction. You are right. Either way, right? Think about it this way. Either way, whether he's in there for some of it or not, I mean, he's not even on the list for next, or was it this week? I don't think it was this week. We wasn't on the list for this week anyway, for the media pool. So hopefully he just doesn't get picked for the media pool on some of the days that, you know, and that's another thing. Scorpio is got this pretty good where he will shoot himself in the foot anyway. This will give him a boost that he'll feel like he got away with something, and ultimately he'll fuck it up somehow, some way, or screw himself more because that's what he did. Well, he does have current indictments. He is currently indicted on the witness intimidation charges. So, you know, so I mean, he will fuck it up. You know what I'm saying? Like, they would be locked up by now. This is the bottom line, is he'd be locked up by now 10 times over if this was a different state. And not even just a different state, but a different person. Let's just make that abundantly clear. Okay, if it was me or you, even in my state, that there'd be no chance that he wouldn't be locked up. I do believe, though, that they are just waiting probably to drop an indictment or a bunch of charges on him once this case is over. Because how else do you let someone consistently get away with blackmail, threatening people, make even dog whistles, the dog whistle threats he makes, those are covered by law. There are charges for things like that. Why he hasn't gotten them yet, beyond me, not sure. But the best I can hope for is for what I had been hearing whispers of, which would be that they're just waiting, I guess. I don't know. Like, Hank, either way, is going to take every single one of these quote expert witnesses that the defense has and take them apart piece by piece, lie by lie. As you saw yesterday when we played Dr. Russell and the voir dire, that was just a voir dire. That's just a taste. That's just a taste of what Hank ultimately is going to do to pretty much every witness that gets up there and tries to lie and keep the. Marie Russell sat there and said she's the only qualified person in the entire country for dog bites. And yet she can't tell anybody whether it's bites, scratches, which teeth it came from, how it's not spaced the way it's supposed to be, why the dog would have had to bit backwards. She can't tell you anything, but she's the only qualified person in the entire country. I'm glad he made that comment in today's thing. We will find the thing about the seatbelt somewhere. We will find it. I remember hearing it. I watched it, so I know it exists. He is going to jail regardless eventually. Why wait? I'll tell you why. Because they don't want to cause an uproar in FKR people during the Karen Reed trial by making him a martyr again. I guarantee you that's why. It's more optics. They worry more about optics than they do who's breaking the actual law. And that is the part that gets me. There need to be some reforms made up at the State House here that the discretion that we allow law enforcement to have gets a little more stringent, because I don't give a fuck about optics. I don't think any of his victims give a shit about optics. Okay. And to whom do the optics matter? To the pink cult? I don't give a shit what the pink cult thinks. I don't think any of his victims do. So to be worried about optics of anything is shame on them. Shame on them. Yeah, she can't even say it was a dog. You know, she can't say anything. She can't say anything. Like, no, he knew he would plead the fifth. But he wanted him to plead the fifth to every fucking question, as he should have to. Because some of those questions, like he said, would not apply to the Fifth Amendment or him. Like, not even a little. Yeah, puncture wounds in the shirt. Like, stop it. I can't. Like, literally. Like, you know what I mean? He definitely knew he'd plead the fifth because the lawyer put something in writing like forever ago, like saying that he would. The point was to make him do it because otherwise it's just an empty threat. It's just an empty threat. It's just something the lawyer is saying to get him out of it if you don't actually make him assert it. You know? That's usually how this works. Yeah, he's really just a little annoying mosquito to Hank. He's not a big fish in the pond. He's just a mosquito. And really all you need for mosquitoes is a little bit of Raid, a little bit of off, maybe some lavender. They don't like the smell of it. And they'll go away or eventually get squashed, one or the other. Like, thank you, freak. I know it's in there. I know it's in there. They say something about Mr. O'Keefe, what time he takes his seatbelt off. And I believe it's 12:31. I can't remember if they exactly said 12:31, but it sounded right when people said it to me. The time part, but I remember the other part very specifically because I watched it. I covered it. And I remember thinking to myself what I was thinking when it happened. So I remember hearing it. Sorry, I'm on it. I mean, reality is Karen's still going to trial. Oh, yes, that was exactly what he said. I wish he would. I would destroy him. Blah, 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 blah. You know, that kind of nonsense. Except now he's saying something very, very different, as we know. As we know. Let's see. Yes and no. I mean, the problem is that him pleading the fifth doesn't really help or not help the defense. Like, even if he didn't plead the fifth, it wouldn't help the defense because all the things that he would have to say are bad for her, not good for her. So it wouldn't be creating any reasonable doubt for her at all. There's no reasonable doubt in the stuff that he has to say. If there was, then yeah. Right, exactly. Prove that they're pleading the fifth. Like, you know? Make them plead it. Like, you know what I mean? Make them plead it. Like, but yeah, back in my day, it's exactly what he said. Yep. It's exactly what he said. But once again, like the giant pussy that he is, he runs to plead the fifth. Well, we can safely say that he's afraid of Hank. And he can say he's not, but he very clearly is. Like, I mean, I'm trying. I'm trying. But I mean, the reality is Karen's still going to trial. Opening statements still start Tuesday. And Hank is still going to take apart every single lie, piece by piece, in any of the witnesses that get up there and lie. It's really that simple, you know? I mean, it's that simple. Because that's ultimately what we're here for is justice. He's just a little bit of a distraction. Ultimately, he'll get his comeuppance. He's got how many indictments hanging over his head? You know, his attorney wanted to sit there and bitch and whine about how many witness intimidation charges he has and how he asserts that the statute is too overly broad and unconstitutional. Well, that's great. You can assert it's whatever the fuck you want, but the courts and the law say differently, sir. And here's the thing with his attorney. Attorney Bradel doesn't really know how to do arguments unless he can insert narrative here. When he cannot insert narrative here, which most judges do not allow, because once again, you don't want the fucking commentary, your opinion. Argue the law, argue what you're arguing that has to do with what you're arguing, and that's that. Nobody wants to hear what you think of the witness intimidation statute. Nobody gives a shit if you think that, oh, it shouldn't have happened or he shouldn't have been charged. He was charged. That is the law right this very minute. So whether he likes it or not, too fucking bad. Like, too fucking bad. Like, so, you know, Bradel doesn't really know what to do with himself when he can't argue narrative. And so when the judge shuts down narrative, and I've seen it in a multitude of judges that have shut down his narrative, he gets a little flustered. He gets a little upset because he can't just then spew shit and try to smear people and throw out Aiden's talking points, because that's all he's there to do, realistically. Like, he's literally just another mouth breather for Aiden Kearney. Like, bottom line. All right. I've been on 4 hours and 21 minutes and I'm starving like a hostage. It's 1:21 in the afternoon. Let me check real quick and see if there's any other donations I need to read. I don't want to miss anybody. It's been a slow day with that anyway, so I don't think there is anything. I just want to make sure because I don't ever want to miss someone. If it comes in after, as you guys know, if you want me to, of course, I will read it tomorrow for tomorrow's show. Nothing there. Let's just make sure. Don't see anything here. My apps need to be updated because I don't know what's going on with them. They're just not popping things up. Yeah, him too. Better Old Clown was also his attorney on the other cases, but Bradel is the main attorney. Better O is an absolute idiot. Like, thank you, Freak, so much. And so I will ask at this time, as I exit and try to go eat something for lunch because I am starving, that you hit the like button, the subscribe button, and that you share the video if you haven't already. And if you want to make a donation to the channel, this is the information right here at the bottom of the screen. And I love your stinking faces. And everybody have an amazing day for the rest of the day. Bye.